Good morning. The Senate Judiciary and Public Safety Committee will come to order. Today is Friday, March 21st, 2025, and we do have a quorum present. Members, we have a long agenda today, and we have some bills that are going to go to other committees as well, and many that have arrived from other committees. So we're going to focus as carefully as we can on the provisions of the bills that relate to our jurisdiction and Judiciary and Public Safety Committee. If the conversation strays too far beyond that, other than trying to get a context for the overall bill, I'm going to try to rein it in. So we kind of know the drill here. We'll stay as focused as we can. So why don't we get started? And I'll tell you, we're going to take a brief lunch break, likely before 1 p.m. So want to make sure everyone is well fed and doesn't get too ornery as the day progresses. My goal is to be out of here late afternoon, certainly before dinner time. So if we all work together, I think we can all have a Friday evening with our families instead of here, but we'll do what we have to do to get the job done. All right, folks, let's start with Senate File 1859, Senator Carlson, relating to the BCA. Senator Carlson, why don't you go ahead and give us a brief description of your bill, or we can have jump right into the superintendent who will testify. There is an A1 amendment, members, in the packet, and this is the first stop for the bill, so that'd be an author's amendment. Right, Senator Carlson?
Yes, Mr. Chair. Yes, right. It is an author's amendment, and it is an A1.
Senator Carlson moves adoption of the A1 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Senator Carlson, tell us about your bill, please.
Thank you, Mr. Chair. This is Senate File 1859, and it is an agency bill, and it's related to the agency's amount of information that is posted on their website. And it, in the background, we've had some, we have the direct information, the direct body cams, the direct video that is related to a case. But then we have what I'm terming the B-roll. That's from other officers' cameras that has to be gone through before it is released. And this has gotten to be quite an extensive amount of work for the agency. And what we have is just making the same information available. Nothing is really different other than just when it's available and what is the trigger for having it available. And with me, I have Superintendent Evans to give more information about it. Being an agency bill, this is something that there's been a lot of interest in it, and also we've had some last-minute changes, and that's what generated the A1 amendment. So, thank you, Mr. Chair.
Thank you, Senator Carlson. Mr. Evans. Superintendent.
Thank you, Chair Latz, and members of the committee. As Senator Carlson noted, what this bill does is that it changes a slight change to what is posted publicly available in our officer-involved shooting investigations. There was a change previously to our state statute that requires in the BCA's officer-involved shooting investigations to post all of the data related to the case on our public website within 30 days of the case being closed. We support that and continue to be able to post that information. What has become extremely difficult for us to meet that timeline is, as Senator Carlson noted, the B-roll. What we're referencing when it comes to this is other extraneous video that is not related to the actual use of force incident. So I'll give an example. The officers responding to the call, they get involved in some sort of altercation, there's a use of force, and then medical attention is provided. All of that would still be posted on the website. What we're asking to not post on the website, but not change anything with the data classification, is all the other responding officers. There's a lot of body cam that has to be redacted, that has to be put up on that website, that doesn't actually capture any of the incident. Generally speaking, we think the public is most interested in the file, our investigative findings, the interviews, the actual video that captures the incident and the events leading up to the incident, rather than all of this other video. The reason it's so onerous for us is we have to redact, pursuant to the Data Practices Act, all of that other video, because it's governed by 13.825, which is the statute governing body cams. And so it's a very onerous task for us to do that. We will still have that video available to the public. If a member of the public made a request for that video, we would process it, and it doesn't change the data classification. So pretty straightforward bill. The goal of this is to make sure the relevant information the public wants to see in these investigations, to be transparent with that and have that ready as quickly as possible for what people are most interested in. I'm happy to answer any questions.
Thank you, Superintendent. Is there anyone else in the room that's interested in testifying in connection with this bill? Not seeing anyone come forward. Members of the committee, any questions for the superintendent? Senator Howe.
Thank you, Mr. Chair. And the question I have is that B-roll that you said that would still be available if they requested it. What is the timeline if someone requests some of that, a specific officer that's there and they request that body cam video? What's the timeline that they would expect to have that done in?
Superintendent Evans.
Chair Latz and Senator Howe, that's a good question and one that's really difficult to answer. If it's a small amount of video, that extraneous video, it shouldn't take too long. We have 9 people that are dedicated to doing data practices, redaction releases at the BCA now. If it is extensive, an example would be in an urban area where 50 police officers responded, and Minneapolis is just an example. They run their body cams from the time they enter a crime scene until the time they really leave the crime scene. It could take, a significant period of time. And that's what's actually preventing us from posting some of these files on the website publicly now. But we will certainly put it in the queue. It's first come, first serve, and then we'll work on it as we have the time to be able to do that.
Any other questions or comments from members of the committee? I'm not seeing any. The Senate File 1859 is laid over for possible inclusion in the omnibus bill. Thank you, Senator. Thank you. Senator Westlin, Senate File 1665.
Taking it out of order. Get the next one.
Expansion of UAV permitted uses. Why don't you go ahead and give us a brief description of your bill, Senator?
Thank you, Mr. Chair.
And actually, before you do that, this is the first committee stop. There is an A1 amendment in our packets. This will be an author's amendment. Senator Westlin moves adoption of the A1 amendment as an author's amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Senator Westlin.
Thank you, Mr. Chair. This bill relates to the use of unmanned aerial vehicles, also known as drones. In 2023, 2,639 law enforcement vehicle pursuits were reported to the Bureau of Criminal Apprehension. The vehicle pursuits resulted in non-law enforcement injuries and damage to not only the property of fleeing vehicles and squad vehicles, but also to third-party vehicles and property. The reasons for these pursuits included stolen vehicles, open warrants, commission of a felony, and driving under the influence. In short, these high-speed chases, both in vehicle and on foot, are dangerous for everyone involved as well as bystanders. By allowing law enforcement to lift unmanned aerial vehicles, pursuits of fleeing suspects would become safer for all parties involved. Lifting UAVs would potentially reduce use of force while also allowing law enforcement more time to de-escalate situations. The amendment that has been added, Mr. Chair, tightens up the language regarding when these drones can be used, and I think makes the bill a bit tighter. There are often concerns raised about privacy for third-party individuals, and I would just note, Mr. Chair, that the current law already provides protections. This is expanding a use of these types of drones, And this bill would be subject, or this language would be subject to those same protections and restrictions regarding privacy of data and privacy rights of third parties. I do have a testifier, Mr. Chair.
Superintendent Evans, welcome to the committee.
Thank you, Chair Latz, and members of the committee. As noted, I am Drew Evans, Superintendent of the Minnesota Bureau of Criminal Apprehension. We thank you for hearing this potential expansion of the UAV statute. What this does, as Senator Westlin outlined, is create one additional exception to the warrant requirement that is in our UAV law. And where this has come from and where we encountered some challenges with the current law is that you need to get a search warrant to be able to utilize a UAV over private property unless there are certain exceptions built into the law. There are a number of privacy protections that are already in place for the data that are utilized with these UAVs, as Senator Westlin testified about. What we've encountered through our work is we've been doing a lot more violent crime work with the city of Minneapolis and surrounding communities. And a lot of that work involves apprehending dangerous violent criminals in the process. As we're doing surveillance, attempting to apprehend individuals who are wanted for some of these various crimes, we see that quite a few people flee from the police. And what we're doing without the ability to utilize this is you're doing traditional chasing. Oftentimes we're running through backyards, jumping fences, going into unknown areas. What we'd like to be able to do is in those situations where an individual chooses to flee is be able to have this as an available tool to be able to launch the UAV, and what we can do is more safely apprehend that individual. We can launch the UAV, and instead of jumping over those backyard fences, we can set a perimeter with our law enforcement, utilize the UAV to be able to see the suspect, be able to determine where they are, set the perimeter, and call them out more safely. That's safer for the individual that we're pursuing, and it's safer for our law enforcement officers along the way. And as noted, there are privacy protections already baked into the law to deal with the data and how that data would be treated with that. So I'm happy to answer any questions about that. We've done this in a way to hopefully be a narrow exception that would keep everybody safer in the process and utilize a tool that we have available to use.
Superintendent, I appreciate the amended language that we put on. I think it's much more carefully, or more tightly drafted to focus on the need here. I know there's always a privacy balancing going on here, and people get nervous about the prospect of a drone flying over their backyard while they're back there barbecuing or sunbathing or whatever they do in their backyards. It just seems to me it's safer for the individual citizens as well to do it this way rather than have officers running through their backyard with guns drawn, chasing a suspect, possibly getting into a shootout with a suspect. If you can narrow it down and call a suspect out when they realize they've got no chance because they've been located, and they're also probably less likely to have citizens caught in a crossfire or worse, taken hostage in some way as a shield. So I think this is a narrowly tailored exception that, to me, when I balance the privacy with the need to safely apprehend someone who's fleeing a law enforcement officer, I think it's a good way to do it. Anyone else in the room wish to testify in connection with this before we go to committee discussion? Yes, come on forward. Identify yourself for the record, please.
Good morning. My name is Alicia Granzi, and I'm a staff attorney at the ACLU, the American Civil Liberties Union of Minnesota. The American Civil Liberties Union is an organization devoted to preserving the rights and liberties enshrined in our Constitution and in Minnesota laws. And I very much appreciate Senator Westlin and the BCA's tightening of the language. I think that it's important to have privacy organizations like the ACLU involved. We have been working on this bill for several years, since 2020, and we do still have concerns, even with the amendment today. The usage of drones has increased rapidly here in Minnesota and across the country. According to the 2023 report by the BCA itself, UAVs were used 4,326 times without a warrant already. This is a 41% increase from the prior year. The ACLU does not outright oppose the use of UAVs. There are legitimate uses for it, but a powerful tool needs meaningful limits. Our concerns here would be the broad scope of potential crimes that could be used, or that warrants, drones could be used without a warrant in this case. There's no limitation. So the BCA expresses concerns with felonies and violent crimes or violent criminals, but that is not something that this bill is limited to. So if someone flees after, say, a trespass, is that going to be enough? Is that something that we want law enforcement engaging in on a daily basis? So we would recommend adding qualifications to what a fleeing suspect is, or what they're fleeing from, to having committed offenses such as homicide, aggravated robbery, criminal sexual conduct in the first and second degree, treason, or other severe and violent felonies that are actually posing a danger to the community. And thank you, Senate Committee, for hearing our comments.
Thank you, Ms. Gramsci. If you want to just wait a moment, see if there are any questions for you from members
Certainly.
of the committee. Senator Kroon.
Thank you, Mr. Chair, and my question is to Superintendent Evans. Have there been situations other than the list of identifiable crimes that the testifier just mentioned where the suspect has chosen to flee and put the public in danger?
Superintendent Evans.
Chair Latz and Senator Kern, I certainly, respect the testimony and wishing to narrow the number of areas that they are, but there's certainly other situations that wouldn't fall within that list where an individual is fleeing that could potentially, pose harm to the community. And so, one of the things with this statute, and we work closely as BCA with the ACLU and appreciate the concerns when the language was originally drafted with the UAV. This was one of the unforeseen consequences as we didn't identify this here. Fleeing individuals has been a long-standing, exception to the search warrant requirement in all other arenas, and so that's partly why we brought it here in terms of pursuit of a fleeing individual. And so I would, I would want to have additional discussion with others and members about what that would look like if we were to narrow that, because I can think of a number of situations where the public would still be significantly at risk at a list much larger than that.
Senator Kroon.
Thank you, Mr. Chair. I'm not an expert in this area, but it seems pretty obvious to me that people choose to flee in all sorts of situations, and to try to limit that to certain underlying crimes. To me, the point is, if law enforcement reasonably believes that they're going to flee, we want to have a mechanism in place to be ready, at least, to use this technology for in the event they do flee. And I think the public safety of that is very important, and for the suspect, for the police officers, and for the public. And so I think it's well drafted right now, and I wouldn't support further limiting this to adding specific crimes.
Senator Howe.
Thank you, Mr. Chair. And Director Evans, could be do we need a search warrant to put the State Patrol helicopter up in when they think someone's going to flee? Do you need a search warrant to put a State Patrol helicopter over this in that area?
Superintendent Evans.
Senator Latz and Senator Howe, no.
Senator Howe.
Well, and and the cost of putting a helicopter up usually runs in the close to about $8,000 an hour, and this to me looks like a much cheaper, more efficient use of our aerial assets to do the same thing as we would do with the State Patrol helicopter. And so in that respect, I appreciate the amendment and the effort to provide us a different way to track those fleeing people without the cost of a helicopter being put up.
Anyone else in the room wish to testify in connection with this bill? Any other Discussion or comments from the committee? Senator Limmer.
Thank you, Mr. Chair. We use the word reasonable in many references in prosecution of criminal law. It's a reasonable standard. It probably changes from one circumstance to another to a degree, but we allow the courts and juries to arrive at that standard themselves. As I'm looking at the operative words that are a little different on lines 1.3 of the amendment, where it adds the words, or who the law enforcement agency reasonably believes might flee. I see that as not a tightening of language. I see that as a very broad standard that could be applied to just about any setting. So can you give me some caution, Superintendent, that this really is something that's tighter language than the original?
Superintendent Evans.
Chair Latz and Senator Limmer, I think in the drafting, which we supported, that was suggested on this in terms of tightening the languages, it does align, as you know, with a lot of other statutory construction related to the guidance of law enforcement use. What it does from my perspective in adding that in is there would need to be a justification that is identified and documented by the law enforcement officer when they use this exception, meaning that it would need to be documented in a report to show what is the belief that led you to the position of believing you needed to launch the UAV in that particular instance. So, for example, it might be that you have a wanted person and you've seen in the past they have fled from law enforcement. That would create that reasonable belief. I think it is more than just we can say people flee from law enforcement. It is a higher standard than that, and that's why I did view the drafting as tighter, that was clearer, that did provide a situation that is analogous to other areas that we are used to in law enforcement, having to develop that belief that we have to document, stand behind, describe before we're able to utilize that language.
Mr. Chair.
Senator Westlin.
And Senator Limmer, the existing statute, if you look at the existing subdivision 3, section or paragraph 6 says to collect information from a public area if there is a reasonable suspicion of criminal activity. So, I mean, there are many instances where the term reasonable, as you note, is used, and there's actually often been a lot of case law around what is reasonable. This basically carves out an exception to obtaining a warrant, and I think that the full statute, as it is currently written, which is 626.19, outlines all of the current limitations on use, and this is just adding one more category where a UAV could be used. So I just wanted to note that there's already existing in the statute a reference to reasonable suspicion of criminal activity.
Okay, Mr. Chair.
Senator Limmer.
One question. As I was reading it, I thought that perhaps a law enforcement agency could reasonably believe that the suspect wants to avoid arrest and therefore would justify a drone to be in the area. And that seems to be logic that would cover just about any circumstance.
Superintendent Evans.
Chair Latz and Senator Limmer, I mean, I think most people want to avoid arrest. So I don't think that from my perspective, that's certainly not our intent. And I think that the language from my perspective, when my agents would be reading this, would believe it has to be heightened beyond that. Not simply that they do not wish to be arrested, but that they have a belief the individual will flee when we attempt to arrest. And the vast majority of people do, they don't want to be arrested, but they certainly do not flee from us on a regular basis. There's usually a heightened degree of why that individual, we believe, will flee.
Council has some information that might also be helpful to consider here relating to remedies or restraints around the unlawful use. Mr. Backus.
Yeah. Mr. Chair and members, the actual statute is not completely before you, only that one subdivision. So 626.19, which is the UAV statute, does have a number of kind of limitations and checks and balances on use. First off, the law enforcement agency has to document each use of a UAV, connect each deployment to unique case number, provide information like that. They have to report use. Evidence obtained in violation of this section is not admissible as evidence in a criminal, administrative, or civil proceeding. And then there's a civil action that can be brought to enforce if an aggrieved party is essentially harmed by a violation of the act. So if you scroll through the statute, you might see a number of protections.
So, Mr. Backus, if someone were stopped from fleeing with the use of a UAV, and they ultimately got arrested for felony drug possession and were charged with that, they could bring a suppression motion in the criminal case asking that the fruits of that arrest be suppressed because of the improper use of the UAV, based on this reasonable belief that they might flee standard. Is that my understanding?
Mr. Chair, I believe that's correct. I mean, the general rule is that to use a UAV, you have to have a search warrant for law enforcement. And then subdivision 3 has all the non-search warrant exceptions. But in terms of that, I can read it to you. Subdivision 7, evidence, information obtained or collected by a law enforcement agency in violation of this section is not admissible as evidence in a criminal, administrative, or civil proceeding against the data subject. So I think what you said is correct.
Superintendent Evans, it sounds like most of these cases would be cases in which your agents or law enforcement would be deciding to chase a fleeing suspect anyway. If they chose to run even from a trespass, I don't know, maybe there'd be, it's not like fleeing in a motor vehicle necessarily, although that would also be covered by this, I think. You know, there's always a judgment call, right? So it might be that you'll use a drone, law enforcement would use a drone where they might not otherwise physically chase someone because it's safer and easier to do it. But just because someone is trespassing doesn't mean the reason that they might flee is because of a trespass violation. It might be because they have other issues going on, like a warrant for their arrest, besides just being scared of being arrested. Am I characterizing this accurately?
Yeah, Chair Latz and members, I think that's, you characterized it well. And as noted, you know, from Mr. Backus, that was very helpful clarification as well with this, that determination would need to be made. And if it is determined not to be reasonable by the court, then that evidence would not be admissible in that situation. For the work we do at the BCA, it tends to be individuals that are wanted for, you know, a number of significant crimes, but certainly it would cover the other scenarios that you noted. I think, you know, pragmatically for a trespass violation, it would be unusual for law enforcement to have a UAV with them, but if they fled, it's still a safer way to pursue that individual if they choose to you know, pursue them in that situation for everybody involved.
And is Superintendent, is the reporting of data detailed enough so that the ACLU or someone else would be able to look at it and determine if the drone were deployed because someone is fleeing, or separately if the drone is deployed based upon a reasonable belief that they might flee, even if they don't in fact start to flee as a preventive measure? Could that data make those two things distinguished so on review we could see? Superintendent Evans.
Chair Latz and members, the reporting requirement here is the number of times a UAV was deployed without a search warrant issued under this chapter, identifying the date of the deployment and the authorized use of the UAV under subdivision 3 that we noted. The BCA does that data collection right now for law enforcement, and so we will have to create a new category that will be specific to this exception, so it would identify that with the date and time. And so if an individual from the public or whoever would be able to identify that use and gather those reports to see exactly what that reason was to deploy it and what that reasonable belief was at that time.
Okay, and we just confirmed in statute, this committee, chairs and ranking members of the legislative committees, as well as others, get these reports. So we could review it, members of the public could review it and could determine if it appears that there's been an abuse of the use as well. One other thing I think is helpful here, sometimes people will flee, not only because they don't want to get caught, but also if they think they can get away. It's sort of like motor vehicle fleeing, sort of like drunk driving, for that matter. I think the most important criteria for some offenses is whether people think they can get away with it and won't be caught for committing it. I can just get home, I know I can make it home without getting stopped kind of attitude. So if they know that a UAV is available for use, should they try to flee, I think they're probably less likely to flee and impact not only law enforcement safety, but the safety of the public. But I agree with Senator Limmer, we got to make sure we've got sufficient restraints on the use of this. And I think what's already in the statute and the public availability of data will be important. Any further questions or comments on this bill? Did you wish to say anything further, Ms. Ramsey, before we wrap this up?
I think one more thing I would say is we would urge the removal of the reasonable belief of a risk of flight, or that they're reasonably going to flee, and limit it to if they're actually fleeing. That would be my request.
Thank you. Any further questions or comments from members of the committee? Well, members, we're going to lay this bill over for possible inclusion in an omnibus bill. Senate File 1665 is laid over. Next bill up is also Senator Westlin's bill, Senate File 1721, relating to reporting requirements for community supervision. The plan here is to, or the intent is to refer this to state and local government. Senator Westlin.
Thank you, Mr. Chair and members. This is Senate File 1721. This is a Department of Corrections technical bill with various provisions to it, and I actually will defer to, well, actually, hold on one second. Sorry about that. Too many papers. This is a budget-neutral bill, Chair Latz and members of the committee. This bill does include several technical changes to sections of statute that govern the DOC, including expanding the exemption from licensing and background checks for federal law enforcement agents that are transporting incarcerated individuals. It refines community supervision reporting processes and adjusts the membership of the Community Supervision Advisory Council. The bill also proposes the repeal of outdated statutes related to mental health care for incarcerated individuals. And the bill is intended to align our laws with current practices and address identified issues within statute. At this point, Senator Latz and members, I will turn this over to Commissioner Schnell, who is here to provide a more thorough walkthrough of this bill.
Commissioner Schnell, welcome to the committee. Go ahead and identify yourself.
Thank you so much, Mr. Chair and members of the committee. My name is Paul Schnell. I'm the Commissioner of the Department of Corrections. And I'm here to provide a closer look at the provisions in Senate File 1721 and explain how they support the work of our agency. One of the changes in the bill addresses a gap in the statute related to protective agents who may transfer or transport incarcerated individuals. The licensing and background check requirements for protective agents was updated in 2024, and the legislature exempted the DOC from those conditions. However, it did not extend the exemption to federal law enforcement agents who also transported incarcerated individuals across the state and across the nation. In fact, it is not an uncommon practice for us to work with the United States Marshal Service, who is transferring incarcerated individuals across the country, and we are able to access services from the Marshal Service. So Ultimately, this bill really explicitly adds federal law enforcement officers to the group excluded of parties. Next, the bill makes requirements to the community supervision statutes. Specifically, it updates the reporting dates for statewide community supervision reporting and consolidates the reports in a more logical manner. By doing so, we enhance the meaningfulness of the information in the reports to the legislature. This change is also important in that it will help ensure that we are providing accurate, timely, and relevant information regarding community supervision efforts in Minnesota. Another important aspect of the bill is the adjustment to the membership of the Community Supervision Advisory Council, or CSAC. As requested by the Advisory Council, the bill extends CSAC's membership to include members of the judicial system, which will help ensure that they have a perspective and expertise when recommendations are made. Additionally, the bill expands certain memberships for public members to ensure adequate representation on the council. The change is also a direct response to feedback from and input of the CSAC group as it stands today. Lastly, the bill proposes the repeal of Minnesota Statute 253.21 and 253.23. These statutes are over 100 years old and were brought to light during the separation of DHS and DCT, when this language was amended rather than repealed at that time. The statutes simply require that Stillwater and St. Cloud prisons, and only those two prisons, are required to notify DHS when an incarcerated individual appears to have a mental illness and to transfer them to a state hospital for treatment. This requirement is very outdated, as the Department of Corrections does provide comprehensive mental health services and no longer aligns with how the state handles mental health care in prisons. In closing, the changes in this bill are technical in nature, but they are necessary to ensure that the Department of Corrections operates effectively and efficiently. I thank you for your time. I thank Senator Westlin, and will stand for any questions you may have.
Thank you, Commissioner. Does any member of the public wish to come forward and testify in connection with this bill? Any questions or discussion from members of the committee? Not seeing any. Senator Westlin moves that Senate File 1665 as amended be recommended. I'm sorry, Senate File 1721 as amended be recommended. No amendment. Senate File 1721 be recommended to pass and be re-referred to the Committee on State and Local Government. All those in favor say aye. Aye. Opposed? Motion prevails. Members, we're going to do a little bit of reordering of the agenda here. We're going to take up the next three Senate files relating to DWI law due to the presence of certain testifiers in connection with those bills, and then we'll circle back after that to Senate File 1492. So next up is Senate File 1484. The next three bills are mine, so we're going to hand the gavel over to Vice Chair Oumou Verbeten.
Senator Latz.
Madam Chair, thank you. Madam Chair and members of the committee, the plan here is for me to present 2 Senate files as individual proposals, then to lay them over, and then the 3rd Senate file is a bit larger DWI bill, and I will be proposing to incorporate the language in the first 2 into the larger bill so it can all travel together. And then I think the next step would be to recommend its referral straight to the floor, is my understanding. Is it? Where does it go? Oh, transportation? Okay. So that's the intent, members. The first bill I'd like to have the committee review, Senate File 1484, makes certain changes to our DWI plate impoundment law. This is a proposal that originated, as I recall, with the DWI task force a number of years ago. Currently, when a person is arrested for DWI, if they have a first-time offender with a test that's .16 or higher, which is twice the legal limit or more, or a repeat offense, the license plate for the vehicle that was involved is subject to plate impoundment, which means on the roadside at the time of the tow, law enforcement is removing the license plates. This could be along the roadside on a highway, a busy highway. It could be at night, it could be in the cold, but then they are removing license plates, taking them back to the police department and destroying them. Law enforcement has found this process to be burdensome, and I would suggest dangerous in some instances, and has a cost related to it as well. So the first part of the bill before us proposes an alternative, that is to affix a permanent sticker over the face of the license plate so that it is not visible anymore as a license plate, and it's clear that it's been invalidated. And then it makes it a crime to attempt to remove that sticker. Then the law enforcement would not have to remove the license plate. They can just put the sticker over it and go on with their work, bringing a person in, not sitting on a tow any longer than they need to, et cetera. The second part of the bill then provides for an extension of the length of time that a temporary permit is valid for the vehicle. Under current law, if a plate is subject to impound, the officer gives to the vehicle owner or the arrestee a piece of paper which is a temporary permit that can be put in the rear window of the vehicle. So even though they don't have a valid plate on the back any longer, they still have valid, the vehicle is still valid to be driven for 7 days. That length of time has proven to be not enough for certain circumstances, especially interlock-related circumstances, when it takes longer than 7 days to make alternate arrangements for valid use of that vehicle. So this proposes to extend that time to 14 days and then makes the temporary permit valid for 45 days if the person is submitted to a test of blood or urine, and that is largely because blood and urine tests don't come back promptly, or not as promptly as a breath test at the station, so there may not even be known results at that point. That's the substance of this bill, and I'd be happy to stand for any questions or additional testimony.
Thank you, Senator Latz. And we have Charles Siegel here to speak on the bill. You can come forward. Just begin your testimony by stating your name for the record.
Thank you. Madam Chair, committee members, my name is Charles Siegel. I'm a private defense attorney with almost 30 years of experience. I practice predominantly in DWI defense work, and I am also here today on behalf of the Minnesota Association for Criminal Defense Lawyers, which is basically a group comprised of about 250 practitioners of criminal defense bar who seek to uphold constitutional rights and equal justice for all. I'm also here as the secretary of the Minnesota Society for Criminal Justice, which is a college of approximately 50 attorneys who are nominated and elected that do predominantly criminal defense with a focus on DWI defense. And although I don't represent the task force here today, when Senator Latz referenced that, I was actually and still am on the DWI task force and am currently the co-chair of the subcommittee for the ignition interlock device program. So I come here today with a pretty good knowledge of what Senator Latz is proposing here, and it frankly just makes good sense for a couple of reasons. What normally happens is somebody will get arrested, as Senator Latz said. They will get that temporary license plate given to them and are then told later on that they need to install ignition interlock, or at least they find out about it. And when they find out about it is debatable, but certainly it's not until after they're released. The people that are arrested in this circumstance are often held in custody for a couple of days because normally it happens on a weekend, so they don't get out until Monday morning when they see a judge. And then at that time, even though they have a 7-day temporary license plate, they find out at that time that they've only got about 3 or 4 days left. The problem comes is that when you need to install the ignition interlock device or enter the ignition interlock device program, what has to happen is you have to apply for the program and then at a certain point provide proof of installation of the machine to driver vehicle services. What happens is that 7 days often expires before the person is able to get or realize that that machine needs to get installed in their vehicle. So literally, procedurally, what has to happen right now is the person has to go to a driver vehicle service center, get a special registration or whiskey plate in order to get that vehicle transported to a garage to have the machine installed. Once they have the machine installed, they can then go back to driver vehicle services and get a regular plate for the vehicle. When we amended this, when we drafted and amended this statute, this was a problem that we actually foresaw, but were unable to address it at that time. But this would certainly fix that problem by giving people enough business days to be able to, first of all, learn that they need the machine in their car and get the machine put in their car while they still have a valid plate without having to make that duplicate process of going and getting a whiskey plate and then coming back to get a regular plate. So it just makes good sense. As far as the sticker portion of the statute goes, frankly, I think it also makes good sense from a practical point of view. What often happens, for better or worse, is in order to protect their safety, a lot of officers will actually simply leave the plate on the vehicle, even though the driver has been handed a notice of impoundment. And so what happens is they go home with a piece of paper that says that the plate is impounded, but the plate is still on the vehicle. And so there are often situations where a driver won't actually realize that their plate is technically no longer valid, and so they end up getting caught for driving without a valid plate. By putting this sticker on the vehicle, I think it will help the driver focus and realize that they need to take some action and not believe that the plate that was left on their vehicle is still valid. Thank you.
Thank you for your testimony. Members, are there any questions? Senator Limmer.
Thank you, Madam Chair. Senator Latz, your proposal makes sense to me. However, I do have just a small question. Close to a third of our year is in winter. License plates get very dirty. Is there any concern that a sticker will not stay on a license plate? And that's the only concern I would have.
Senator Latz.
Madam Chair, Senator Limmer, one of the world's foremost adhesive manufacturers is in Maplewood, Minnesota. That's 3M. They probably make the stickers, for all I know. I've certainly seen their products, stickers all around the world, actually. So my guess is, but I think it's a practical question, and maybe the officers will have to carry a rag around with them to wipe down a dirty license plate in order to affix the sticker. Although Mr. Siegel points out to me, the law requires that it be clean enough, at least it can be seen and identifiable as a practical matter. There might be some times when that's a difficult challenge, but we do the best we can.
I'll give you the benefit
Senator
of the
Limmer.
doubt. Senator Latz. Thank you.
I will say I have the unfortunate timing of having to renew my tabs in February every year. I still manage to get it on there. I think the adhesive that they use is very strong. So.
In the last tabs that I got, Madam Chair, I just had to renew on one of our vehicles. It said it needs to be like above 20 below. So it'll stick anything above -20, it seems like.
Yeah. Any other questions? Senator Howe?
Thank you, Madam Chair. And Senator Latz, I will say, though, right now, the transportation, we are having a ton of discussion because those stickers that now are stuck on the plates instead of, we used to have them embossed where they were raised, and now it's just a 3M sticker. We are having a ton of problems with those plates and those stickers delaminating and just disappearing. So that is an issue that we were currently discussing because we've seen boxes and boxes of plates off of vehicles that are just deteriorated and gone before their 7-year time place to replace them. So that is an issue that we're currently struggling with. Thank you.
Senator Latz?
Madam Chair, Senator Howe, are those the plates themselves or stickers placed on top of the plates?
Senator Howe?
Both. The stickers are disappearing and the plate themselves are dissipating. They're almost, you can see them that it almost looks like they're going in half. And I actually have a plate on one of my vehicles that is starting to delaminate currently.
Madam Chair,
Senator Latz?
the point for these plates is that they will not be used anymore. It's just a matter of who's going to remove them and dispose of them at this point. And the plate information is still entered in the driver and vehicle services system as impounded and invalidated, even if they could pull the sticker off somehow.
Senator Kroon?
Thank you, Madam Chair. Most of the bill seems fine. The only question I have is the 45 days for a temporary permit if the violator submits for a chemical test rather than a breath test or refusal, I believe. That seems to be a big difference. It may be not a big deal at all. I'm just wondering what your thoughts are on what the incentive there might be, whether there's no difference or whether it's good or bad or indifferent. Just wondering what your thoughts are on that.
Madam Chair?
Mr. Siegel?
Thank you. I may be able to answer that question or address that question if I may. So the way the statute is currently written, Senator, is that there are two scenarios. One is if you take a breath test and your plate is to be impounded, you have 7 days that we are now seeking to increase to 14. Secondarily, if the vehicle being used is not owned by the driver, then it's 45 days. The proposal that Senator Latz has here, I do not believe respectfully will come into play, because if somebody gives a blood or urine sample, neither their license nor their plates are revoked and impounded at that time. It isn't until the test result comes back that Driver Vehicle Services will take some action. And it is at that point that they will receive a notice in the mail from Driver Vehicle Services that their plate is being impounded and that their license is being revoked. So I think you make an excellent point that I don't know that that particular 45 days will ever come into play, because the action won't be taken unless or until that test result comes back positive. And the whole reason we wait is because if somebody does come in under the limit, or if somebody comes in less than 0.16, then there would not be a basis to take the plate in the first place. And that is why, the way the statute is currently written and applied, we don't take any action until the test result comes back.
Senator Latz.
Madam Chair, in light of this clarification, I move that the new language on lines 2.29 to 2.30 be deleted.
I'm just going to have Mr. Backus read what the exact amendment is.
Madam Chair and members, it would be lines 2.29 to 2.30, delete the new language. So you delete that entire section.
Okay, Senator Latz has made the motion. All those in favor say aye. Aye. Opposed? Okay, the amendment's adopted. Any further questions? And Senator Latz, we're laying this over, then moving to the other bills, and then we'll work on incorporating into the last one. That's correct?
Yes.
Okay, so with that, Senate File 1484 is laid over. And we'll move to Senate File 2363. Senator Latz.
Madam Chair, thank you. Senate File 2363 was drafted in response to a fairly recent Supreme Court Court of Appeals decision just in January of this year, which interpreted Minnesota Statute Section 1.19 in a way that was different than had been the actual practice and expectation of the bar, as well as, I believe, the Department of Public Safety. The decision was consistent, however, with the practice of the appellate courts in more recent years of reading the statutes very tightly and only authorizing jurisdiction in the courts for the causes of action that are or the topics that are explicitly listed in the statute. In this particular case, 171.19 is a provision which gives jurisdiction in the court to consider challenges to license reinstatement decisions by the Department of Public Safety. But the itemized list of jurisdiction covers where the license has been refused, revoked, suspended, canceled, or disqualified by the commissioner. There was a situation where the commissioner's action in negatively impacting the length, by extending the length of the interlock program requirement, turned out to be not subject to review, where the driver disputed the grounds for the commissioner's action in extending the interlock requirement, and yet the reading of the statute did not provide for judicial review, and basically then there was no remedy for a driver who disputed the commissioner's action. This happens, for example, if someone attempts to start a vehicle and they blow a .02 or higher, the vehicle doesn't start. It turns out they think the machine is malfunctioning for some reason, and even though it gets reported to the department, and the department, as a consequence of that purported violation, extends the length of interlock, the person has no grounds basically for getting into court to say it was 20 degrees below zero, the machine wasn't working properly. Mr. Siegel can also give a good example as well. But that's the basis for this proposal.
Mr. Siegel?
Thank you, Madam Chair, committee members. In 2023, we modified Minnesota Statute 171-306, Subdivision 5, which is the Ignition Interlock Device Program statute. And what we did is we created a uniform, or I keep saying we, it's not me, but what DVS did, what the law became, was that if somebody violated the terms and conditions of the Ignition Interlock Device Program, it created extensions of time that you would be on the program. A first violation would increase your time by 180 days, a second offense 1 year, a third year 545 days, or a year and a half, and it would be consecutive. And so any further violations would also be 545 days. And so what happened is when they did create that law, they did not amend Minnesota Statute 171.19 to specifically enumerate a judicial challenge of these extensions. Currently, with anything related to driver vehicle services, often when you receive the notice, it will say to the driver, you have the option of administrative review, or you have the option of judicial review. And in fact, even the extension notices up until recently had that language on them, because even they thought that there was the right of judicial review. And so when we had the Reese case come down, which is the decision case we're talking about here, the Court of Appeals very specifically said this particular portion is not yet enumerated in the statute, and so we don't think there's jurisdiction to do it. And so I'll give you a good example. Somebody gets in their car in the morning, they blow into the machine, it comes back at 0.03. They know they haven't been drinking, they know that they didn't do anything wrong, and so 15 minutes later they blow again to try to start their car again, because they've been locked out for a period of time, but they try to start their time again. This time it comes back at all zeros, and so they start their car and they go. Now the violation of 0.03, when the computer sees it, it says you violated, you're going to be extended. What we as defense attorneys do, whether it's administratively or judicially, is we show to the court or to driver vehicle services, you cannot go from 0.03 to zeros in 15 minutes. It's not physically possible the way alcohol dissipates. And so it's very obvious that an interferent played a part in this. Now, oftentimes when we send those types of challenges to driver vehicle services for administrative review, they will act based upon that, and they understand that. But there are going to be other circumstances where it may be a more nuanced legal issue. And right now, without the opportunity to file for judicial review, only administrative review comes into play. And administrative review is often much more perfunctory in the sense that they're looking to see, was there a violation, and did we impose the right amount of time as an extension? Was this their first violation? Did we impose a 180-day extension? That's right. And so they can simply do that. And that's done administratively without me ever being in the room to talk with them. I can certainly file a letter in advance, but if I have follow-up points or follow-up comments, I can't make them, because the way the law is set up right now is you get one administrative review. And so if they make the determination and you think there was an error or you want to challenge it or anything like that, we have the right to go into court and fight that, except for this. In this case, if I go back to driver vehicle services and say, I think there was an interferent here, they will say, well, sorry, we've already made a ruling on that issue. And that has happened to my clients several times, where they tried it on their own and then they came to me and I could no longer file for administrative review. Thank you.
Senator Latz?
I have nothing further to add at this time.
Okay. Any questions? Okay. Well, with that, Senate File 2363 is laid over, and we will move to Senate File 2068. Senator Latz. And we have a number of testifiers if you want to make your way down. Mayor Nadia Mohammed, the Chief of Police, Brian Gruhl, and President of Methodist Hospital, Jennifer Meister, can come forward. And Senator Latz, I think there's some amendments you need to put onto the bill first. Would you like to address that?
Yes, Madam Chair. Thank you. I have some author's amendments, so I think the way I'm going to do this, there's an A2 amendment, which captures a number of things, including the previous two bills. And then there's an A3 amendment, which I'm going to incorporate into the A2 amendment. I'll make it all as an author's amendment. We'll have a few clarifications to follow up with council as well. But at this time, I incorporate the A3 amendment into the A2, and I move the adoption of the A2 amendment as an author's amendment.
Sounds good. I'm just going to have Mr. Backus clarify a few things in the A2 that incorporates the A3.
Thank you, Madam Chair and members. So the A2 needs to be further amended. If you look on page 2, line 18 and 19, to be consistent with what we did in the earlier bill, that sentence has to be deleted. So delete the new language, line 18 to 19 on page 2. And then an additional amendment, which we should have caught earlier, would need to be made, and that is on lines 2.14 to 2.16, delete that new language. That's necessitated by the earlier amendment. We should have done that at the same time. But then there's one other, and the page handed out a photocopy of section 169A.60, which is the plate impoundment law. If you can look at subdivision 6, surrender of plates, it says within 7 days, the 7 should be stricken and 14 should be inserted to be consistent with what you've done earlier. And then all of that can be kind of incorporated into this A2 amendment.
Thank you, Mr. Backus. So Senator Latz moves the A2 amendment as described by council. All those in favor? Aye.
Aye.
Okay, that amendment's adopted. Senator Latz.
Thank you, Madam Chair and members. I'm going to give a brief background for the reason for this bill, or the bill that's what has motivated us to look at these portions of the laws more closely. Here's some testifiers as well. Many of you saw in the news last summer that a drunk driver drove through a populated patio at the Park Tavern restaurant in St. Louis Park. He killed 2 people, injured 9 people, and no, 4 times the legal limit. I think his alcohol concentration was at 0.32, if I remember correctly. He was, other than being drunk, he was driving on a valid license. So he was lawfully behind the wheel in that respect. He had 5, I believe, prior DWIs going back to 1999. But he had complied with all of the law requiring length of license, revocations, cancellations, ignition interlock, abstinence periods, and so on. He had completed a 6-year cancellation with interlock, proven rehabilitation, been reinstated a few years ago. His most recent event had been 2015. So obviously he should not have been behind the wheel when he was drunk, but it highlighted for us policymakers, Representative Kraft and me as the legislators for this area, the need for ignition interlock to apply to circumstances like this. This driver was apparently compliant with interlock requirements when it was required. So we went back and took a look at the DWI statutes. And what you have before you today, in its essence, is a proposal to extend the length of the time that the interlock is required in most circumstances. Actually, I think in all of the cases where interlock is required. It would not apply to first-timers, but it would apply in an escalating number of years to repeat offenses. To extend the look-back period for purposes of determining whether interlock is required from the current 10 years to 20 years. And that's the essence of the underlying bill. Had this law been in place at the time, had the driver been compliant with interlock requirements, he would have been driving with the interlock in the vehicle. Without alcohol in his system, and this tragedy would not have occurred. There are some other elements to the bill. The only other one I'm going to mention here, which was part of the amendment at this time, is the addition of criminal vehicular homicide to the ignition interlock requirements. I will go into that in some more detail after we hear our testimony, but I want to note that for the committee's attention as well. With that, I'd ask the committee to hear the testifiers.
Begin with you, Mayor Mohammed. Good morning, Madam Chair and members of the committee. Thank you for the opportunity to testify. As mentioned, my name is Nadia Mohammed, and I proudly serve as the City of St. Louis Park's mayor. The City of St. Louis Park supports this bill, strengthening Minnesota's DWI policies to improve public safety. We appreciate Representative Kraft and Senator Latz efforts to introducing bipartisan legislation reforming Minnesota's DWI policies and making our communities safer. I look forward to supporting this legislation as it moves through the process. This bill was introduced in response to the Park Tavern crash in 2024 and the Jeb Olson traffic accident in 2025, which was more recent, both which highlighted gaps in the current law. I will pause at this moment and say that we mourn the loss of our community members, and we send our deepest condolences to the families and those who were impacted by these tragedies. This bill extends that being said, this bill extends the ignition interlock requirement for repeat offenders, expands the look-back period from 10 years to 20 years for a second DWI offense. St. Louis Park Police have encountered offenders who fall outside the current 10-year look-back period, preventing them from receiving extended interlock requirements. Our police chief is here to testify more on this issue, so I will let him talk about that. However, I will say this, that we do recognize the connection between substance abuse and impaired driving and remain committed to finding multi-pronged solutions that address both public safety and recovery support. I urge your support for this bill and appreciate your time today. Thank you, Madam Chair.
Thank you. Thanks for being here, and thank you to the Chief of Police for being here. You may begin.
Thank you, Madam Chair, committee members, Senator Latz, for having us here and your work. I'm the Chief of Police in St. Louis Park, Brian Crewley, and this is definitely important, proactive work that all of you are taking on, addressing a significant community issue of impaired driving and the far too frequent harm that it causes, including the deaths of innocent bystanders in the motoring and pedestrian public. In just a short number of months in St. Louis Park alone, we've experienced 2 separate impaired driving incidents that have resulted in the deaths of 3 individuals with significant injuries inflicted upon multiple other victims as well. Impacts that are felt by countless family members, friends, the broader community, and our first responders who arrive on these scenes where so many of those individuals that I named will now face the ongoing wellness challenges that lay ahead. The opportunity that this bill presents is the potential to stop tragic impaired driving events from happening due to the expanded interlock restrictions that an increase in the look-back period can provide. I can tell you firsthand from being involved in impaired driving arrests, both as an officer and as a supervisor, that far too many prior DWI convictions do not get accounted for because of the clock stopping at 10 years. This change can make a difference and actually save lives. I also appreciate the thoughtful nature of the bill where it is considered the financial challenges that are faced by so many who will need to have interlock devices installed on their vehicles. By helping to reduce some of the barriers associated with interlock fees, I believe we lessen some of life's pressures that so many face and thereby help resolve those underlying issues. Not only in St. Louis Park, but statewide data shows us that impaired driving is still a significant problem plaguing our roads and communities. With 124 statewide fatalities just last year, it's up from the year prior to that. An issue that is also compounded by the active use of our drivers with electronic devices. We know that's illegal, but we also know, as those who are out on the roadways, that that's far too often ignored. The companion piece of that, in conjunction with impaired driving, just heightens this issue even further today. I believe this Senate file can make a meaningful difference in addressing the problem, and that is why I am here today in support of it. Committee, thank you for your time.
Thank you both for testifying, and I think we definitely want to share in condolences for the lives lost and just the impact on your community. We have one more testifier, President Jennifer Meister, so if one of you could make room for her. But again, thank you so much, Chief Crewley and Mayor Mohammed. And you may begin.
Thank you. Madam Chair and members of the committee, my name is Jennifer Meister, and I have the privilege of serving as the president of Methodist Hospital in St. Louis Park. I'm here to support this important legislation in the hopes that others are spared the pain and the grief caused by the preventable tragedies like what took place back in early September at Park Tavern, where we had a group of employees there celebrating an accomplishment for one of their colleagues. As you're aware, a drunk person, Stephen Bailey, drove onto the patio of Park Tavern in St. Louis Park, killing one of our colleagues at Methodist Hospital, one of the servers at Park Tavern, and he caused life-altering injuries to many others, including 4 of our colleagues at Methodist Hospital. We understand that this legislation will not prevent all tragedies, but it's an important measure for prevention and safety. Thank you, Senator Latz, for your leadership on this bill. We ask the committee for your support, and I'm happy to answer any questions on behalf of Methodist Hospital and Health Partners. Thank you for your support.
Thank you for your testimony. And again, if you want to just hang tight, we have one more testifier, Mr. Siegel. If you want to come forward, and then we'll see what questions the committee has for Senator Latz or any of our testifiers.
Thank you, Madam Chair, committee members. As I had mentioned earlier, I am here on behalf of the Minnesota Society for Criminal Justice and the Minnesota Association of Criminal Defense Lawyers. And so I bring the defense attorney perspective here today. And although any fatality related to alcohol offenses or any at all on our roads is a tragedy. And certainly even MACDL and MSCJ want nothing more than to see Minnesota roads safer. It is our position, however, that we feel that portions of this bill will not accomplish that goal. Currently, the way the law is set up, if somebody has a 0.16 test result or they are a repeat offender, they're required to do the ignition interlock device program. So there already is in place a requirement to do the program. This does not expand that. What it does do, though, is it extends the look-back period and it extends the amount of time the person will be required to be on the program. And certainly when we look at these respectfully outlier cases like the Park Tavern tragedy, and it is a tragedy, this was an individual, as Senator Latz had said, who had already been on the program for 6 years and then was successful on that and then reoffended. To increase that person's requirement to be from 6 years to 10 years, it is our position that while it may for those 4 years provide some safety, at the end of the day, the reality is this person was likely to reoffend anyway. What we have seen statistically is just over 40% of DWI offenders will reoffend. And so when those people are put on the ignition interlock device program, it is the first time they've experienced it, because a first offense, unless it's a 0.16 or more, doesn't require it. And so I have not seen any studies that have shown that putting somebody on the machine for 1 year or for 2 years instead of 1 year will act as an increased deterrent from reoffense. The reality is when we talk about a 40% recidivism rate, we're also talking about almost 60% of people never reoffending. And so people will come into my office with a second offense, and I will tell them you're going to have to be on the ignition interlock program for 1 year. And here's what it costs to install the machine, typically, approximately, and here's what it's going to cost per month. And so to tell them that, what it then does is it lets them look at it from a financial point of view. And in my work, now let me be clear, I'm not here speaking for the DWI task force. I do not have that authority. However, as the co-chair of the Ignition Interlock Device Program Subcommittee, I have spoken with many probation officers who oversee implementation of the Ignition Interlock Device Program for a lot of the folks that just don't have the financial means. And what we see as a big barrier repeatedly is the cost. The cost is prohibitive. And so when they're told they need to be on the machine for 1 year, it's already creating a scenario where they can't always afford. And there are some subsidies and there are some programming that is available that is very helpful, but at the end of the day, it becomes a deterrent to enter the program. And by extending the time periods, I think we only serve to deter even more people who are not financially able to do it from entering the program. And in my opinion, to not have them in the program and the likelihood that they will drive anyway, because that's the reality in Minnesota, we need to drive. My concern is we're actually making the roads less safe because less people will be complying with the requirements of the program. And so from a financial point of view, we would recommend that the period of revocation or the period of time they're required to be on the ignition interlock device program should remain the same. Certainly we recognize and understand that being on the ignition interlock device program does essentially serve as a deterrent for most people and certainly increases safety in the roads in Minnesota. We would never want to see that disappear. We simply believe that extending that time period won't necessarily solve the problem and is merely addressing these outlier situations that occur. I would like to thank Senator Latz for the amendment that he talked about today. I personally had not yet heard about it, but one of the things I did want to bring up today is that people who are convicted of criminal vehicular homicide are revoked for 10 years or more and currently have no means of legally driving. In other words, the ignition interlock device program is not available to them. And so by adding that a possibility, I think we are making roads safer, because if we tell somebody, you just can't drive for 10 years, again, Minnesota, the reality, they're going to have to drive. And so by giving them no option, they have no option but to drive illegally. If we create the scenario where ignition interlock device is installed on the vehicle, we know that's going to reduce recidivism. We know that's going to make the roads safer. We most importantly know that that driver will have an option to legally drive in the state. And so to add the criminal vehicular homicide statute to be eligible for the ignition interlock device program, I think serves every legitimate purpose we could possibly imagine to increase safety for the roads in Minnesota. Thank you.
Okay, we heard a lot of testimony. Just wondering if you had any additional comments, Senator Latz, or you want to move to questions?
Thank you, Madam Chair. I just wanted to highlight a couple additional provisions that are in the bill. One is, as Mr. Siegel just identified and I noted earlier, is the addition of the criminal vehicular homicide provisions to eligibility for the ignition interlock program. When we expanded the interlock, I carried the pilot program for interlock in Minnesota, authorizing that statute. And when we expanded it, there was some uncertainty about whether it ought to go to include people who have killed someone by driving drunk. And it seems to me that those are the most important cases to have covered by interlock, the ones who are most tragic in that regard. So I'm pleased to include that coverage here in this bill as well. So that's included here. In response to the financial barriers to getting into the interlock, that is a very real concern. It's expensive after you get a DWI for a lot of reasons. The interlock itself will cost usually over $300 to install the device, over $100 a month to have it maintained and have the data downloaded for the DVS system. And then when you're done, you got to pay to uninstall it as well. We don't have quite as much control over those costs, but what we do have control over here is the cost of reinstating the driving privileges. Any DWI has to pay by statute a total of $680 to Driver and Vehicle Services to reinstate their driving privileges. Most of that was simply a remedy at one point to a budget shortfall to help close a budget gap. But it doesn't matter to the driver where the money is going. It matters whether they've got the money to pay. And so to reduce that upfront cost of getting the interlock installed, to promote it being installed promptly, this bill removes that requirement for immediate or prepayment to have the interlock installed. It doesn't eliminate the requirement altogether, but it does remove it up front. So for first-time non-interlock people, they'll still have to pay the $680 to get reinstated. But if the interlock's involved, you're going to install the interlock, you won't have to pay the $680 up front, but you will have to pay it sometime during the duration of the interlock program. You won't be able to get your full driving privileges without interlock reinstated until you've paid that up. So those provisions are in this bill. And then one last piece to promote people who are required to drive with interlock to, in fact, drive a vehicle only with interlock, which is part of the program. Or I should say, to deter them from going and driving some other vehicle anyway, we increased the penalty in this bill to a gross misdemeanor consequence. If you are caught driving driving a vehicle not equipped with the interlock when you are required only to do so. People, when they get reinstated with interlock, they're going to know also if they choose to drive some other vehicle in the household or a friend's vehicle, or they go out and buy a junker and drive that vehicle without interlock, they'll be committing a gross misdemeanor offense, not a misdemeanor, which is current law for that. And with that, I'd be happy to answer any further questions.
Okay. I'm not seeing any questions from committee members. So the path for this bill is to go to transportation. So Senator Latz moves, oh, okay. Senator Latz, I'll let you make the motion. I think it's a little bit longer than I expected.
Either way. I'll take a deep breath first, Madam Chair. I move that Senate File 2068 as amended be recommended to pass and be referred to the Committee on Transportation, and that council be directed to make any technical or clarifying changes necessary to reflect the work of the committee.
Thank you. On that motion, all in favor, say aye. Aye. Any opposed? Okay. Sounds like that bill is on its way to the Transportation Committee. Thank you, Senator Latz.
Thank you.
We're going to take up Senate File 1905 next. So I'll hand the gavel back to Senator Latz.
All right, Senator Oumou Verbeten, you're here with Senate File 1905, two-year bill.
Thank you, Madam Chair. Senate File 1905 will disallow the fluid in water pipe from being considered when measuring the weight of a mixture of drugs. And this is done by repealing the language that's currently in statute that states that more than 4 ounces of water pipe fluid can be considered a drug mixture. This bill is really necessary because there are folks who have been impacted. Testifier will be able to speak to this as well, but a woman was arrested in Polk County last year, pulled over for a routine traffic stop. Officers found a water pipe with methamphetamine residue and water still inside of it. If you remember in 2023, we passed legislation that made neither the possession of the drug paraphernalia or the presence of any of that residue on paraphernalia a criminal offense. But despite this, because of this law that is in statute, that woman is facing a fine of up to $1 million and jail time of up to 30 years over 8 ounces of water that were in her water pipe. And that's really because we have this current limit that I would say is pretty arbitrary of 4 ounces currently in law. So as the law's written, it doesn't matter how much of an illicit drug is present in the mixture as long as the weight requirement has been met. So in this case, a water pipe, if more than 4 ounces of fluid are present, the law applies. So it's as if the 8 ounces of water contained that do contain the residue, it's treated as 8 ounces of pure methamphetamine. And so the last thing I would just mention is that we had a 2024 report on the approaches of illicit drug use in Minnesota. We funded that report, and they concluded that neither arresting people for drug use and criminal repercussion for simple possession nor drug paraphernalia laws our successful drug policies. And so I think it's time for us to fix that. Folks are, in this case, facing up to 3 decades in prison for really unsuccessful drug policies. The last thing I would say is that it's also sort of a procedural loophole, and it doesn't really reduce drug use or lead to more safety. It's really placing a burden, I would say, on our already stretched thin criminal justice system. So looking to right that wrong here and hope I can get your support. And we've got the ACLU here to testify.
Thank you, Senator Oumou Verbeten. We have Alicia Granzi, staff attorney, and when you're ready, please introduce yourself for the record and begin your testimony.
Thank you, Madam Chair and the committee. As you mentioned, I'm Alicia Granzi, a staff attorney at the ACLU of Minnesota, and we are in strong support of Senate File 1905, which is a much-needed legislative fix to an archaic and arbitrary statute. The history of drug laws across the country has been overly punitive, disproportionately enforced, and has led to very little improvement in public safety or even a reduction in drug use. Minnesota generally makes drug penalties harsher based on the weight of the drug mixture possessed by a person. After a 2009 Minnesota Supreme Court ruling, which confirmed that pipe fluid or bong water was a drug mixture and possessing it was a crime, the legislature took up the issue and exempted less than 4 ounces of pipe fluid or bong water from consideration of weight. But now it's the time to exempt any amount of bong water from criminal penalty. The law as it stands acts as a loophole to artificially inflate the severity of a drug possession crime. It treats bong water as if it were pure methamphetamine. For example, instead of treating it as a residual amount in drug paraphernalia, which this body correctly decriminalized previously. Very few prosecutors do take advantage of this loophole, but there are cases every year that get charged. The ACLU of Minnesota is currently defending Jessica Besky, a woman from Fargo who's been charged with first-degree drug possession, which has a maximum penalty of 30 years in prison and a $1 million fine. And that's for alleged possession of a bong containing 8 ounces of water, which is about the coffee you drink in the morning, a cup of coffee. 4.1 ounces of bong water, which is about half that cup of coffee you drink every day, weighs 118 grams. 3.9 ounces of bong water weighs about 110 grams. Both are more than twice the weight for a first-degree drug offense involving methamphetamine, but only one is a crime, and only one is going to send you to prison for 30 years. There's no non-arbitrary reason for this distinction. People don't ingest bong water to get high. They don't dissolve drugs in bong water as a method of storage. It's inefficient. No one would do it. People use bongs, water bongs, partially to mitigate some of the actually harmful effects to their body of smoking methamphetamine. It's better for your lungs. These are not the drug kingpins that statutes like this are meant to target. They're just everyday users who struggle with drug use and substance use disorder. Minnesota is an outlier on this, and for good reason. Harsher drug laws and extreme drug prosecutions don't lead to increased public safety. Senate File 1905 is an easy legislative fix needed to ensure that these punitive and disproportionate legal charges don't continue. Thank you very much. I welcome any questions the committee might have for me.
All right, we have Curtis Hanna online to answer questions if needed. Are there any questions or comments from members of the committee? Senator Howe.
Thank you, Madam Chair. And I guess my question would be is, is there a way to separate out this product from the water to actually know what you have?
Ms. Granzi.
Well, I can say that there would be physically a way to do that. Currently, the BCA doesn't have, from what I understand, a procedure to do that, and that is not what's happening in these cases. Something that could happen was that they would essentially evaporate all the water and see what's left over. Although, again, I'm not a drug chemist, so I don't have an exact answer.
Senator Howe.
Thank you, Madam Chair. And so my question is, you know, you made the statement, this is not how they transport it, but if I wanted to transport it, if I wanted to do this, and I just put it in a bunch of water, and now I'm clear because now it doesn't, is that a possibility? I mean, the question is if we don't know how we can separate it, or if it can be separated, are we making a loophole that now, if you wanted to transport this stuff, now it would be able to be transported, and then opening up a Pandora's box that we can't close?
Ms. Granzi?
Thank you, Madam Chair. Senator Howe, I believe that this very same issue came up in 2009, but while certainly someone could put methamphetamine in water, it just doesn't happen. It's not a practice. And again, the amount we have here, 4 ounces, a very small amount of water. And that's enough to put you over. So, I mean, think about like a little cup of, half a cup of coffee is how much water. So there's not actually, even if you put a bunch of methamphetamine in there, it would still mostly look like methamphetamine. That would kind of, you know, again, I'm not a drug chemist, but it's possible, certainly. But again, it's not what happens, and the BCA or, you know, the Senate could make changes to talk about purity.
Madam Chair.
Senator Oumou Verbeten.
Thank you. I would also say, I think our laws try to distinguish between sort of those dealers and people with really bad intentions and then end users. And this was really a case of residue where we have already, I think, spoken on that issue and said, you know, paraphernalia and the remaining residue isn't something that folks should be penalized for. So I think the nature of how this shows up in bong water, that's really an end user and, you know, not the folks that we're looking to criminalize.
Senator Limmer.
Thank you, Madam Chair. I hearken back to a number of different debates that we've had on this issue. For quite a few years, testifier had said that methamphetamine is used in a bong. And the reason why we have severe consequences is not so much because of the weight of the product, but because of the quality, the almost instantaneous addictive nature of the product being used. And that's why the penalty has been as harsh as it has been in the law. And so since that time it was passed, I remember those debates. Since that time, there's been numerous dates and times when we've tried to amend these laws as we're doing now, but the discussion always centers on the weight and not the addictive quality of the product. So just as a little history note, that's why some of our penalties are so harsh. It's because of the instantaneous addictive quality of the product and the danger it imposes to the individual. Thank you.
Any other questions or comments from members of the committee? Okay. All right, hearing none, this bill, Senate File, what are we talking about? 1905 is laid over. Our next bill is Senate File 1492. Chair Latz, to your bill.
Thank you, Madam Chair and members. Senate File 1492 establishes a civil commitment coordinating division within the Minnesota Attorney General's office. The purpose of the bill is to establish a location where a larger scope, proactive view of our civil commitment system and its interaction with the criminal justice system and the mental health system more generally can be evaluated, assessed, and evidence-based, and give us the resources to get that perspective. This would create a staff person as a part of or a division within the Attorney General's office who would do a couple of things. One is would take a look at the overall commitment system in Minnesota and prepare recommendations as to what improvements could be made, where there are gaps, where things are working well and then need to be supported. Secondly, they would gather data to inform that assessment and evaluation, so we have evidence to recommend how we proceed on that. Third, it would that position, that division would interact with an advisory committee with a variety of stakeholders from various perspectives in the mental health space, so that we get broad information and input as well. The bill got started because of an individual parent's experience of loss, a child that died related to their own mental illness and their poor interaction with the criminal and civil justice systems that preceded that. In many ways, they simply fell through gaps in the system that were not cared for well. That led to some broader evaluations and more input from a number of stakeholders in this space that highlighted other cases where maybe where the tragedy was just as bad, or where there are ongoing issues where family members simply are not getting the care that they need. And it identified gaps in the system and ways that we can improve things. So we have put together this proposal for consideration by the committee. The intention is to have this go to state and local government and then be referred back to our committee for final determination and to cover any fiscal note that is related to it. I want to recognize the value of input from former Representative Mindy Greiling, who has been a key part of putting this all together and coordinating the proposal as well, and who has a lot of personal family experience in this space. Norman Ornstein, a Minnesota native who now resides in the Washington, D.C. area, whose son tragically was lost following his mental illness. Professor Larry Jacobs at the Minnesota Humphrey School, who has taken a strong academic interest in advancing these proposed remedies. So at this point, I invite the committee to hear from the testifiers.
Thank you, Chair Latz.
And I will have an author's amendment as well whenever the chair is ready for that.
All right, let's deal with the author's amendment first. Chair Latz, I believe this is the A3 amendment.
That's correct.
All right.
I move the A3.
Chair Latz moves the A3 amendment as an author's amendment. All those in favor say aye. Aye. Any opposed? The A3 has been adopted. Our first testifier is Lisa Daly, if she could come forward.
Thank you, Madam
Daly.
Chair, Committee.
Thank you. If you could introduce yourself for the record and then begin your testimony.
Yes, my name is Lisa Daly. I'm the Executive Director of Treatment Advocacy Center. It's a nonprofit that is headquartered in Arlington, Virginia. I'd also like to add that I am a Minnesota native, and I lived in Minnesota for 18 years before joining Treatment Advocacy Center. I have a sibling with schizophrenia who has encountered the civil commitment system in Minnesota many times. And I am happy to answer any questions after I give my testimony today. So Treatment Advocacy Center is an organization that evaluates civil commitment statutes and the systems that the various states have. And I will say that when the 2020 civil commitment law passed the Minnesota Legislature, it was evaluated by my organization. It was given very, very high marks. In fact, it's the highest grade that we have given for a state civil commitment statute. And I commend the Minnesota Legislature and the stakeholders that were involved in that process for passing what is a very good bill and has become a very good law that will give a lot of opportunity for people who are the most vulnerable within our communities. I am here to testify because I have continued to hear from a number of constituents in the Minnesota area that there are problems with the implementation of this very good law, and that is part of the impetus for wanting to evaluate whether or not having a civil commitment coordinator housed at the Attorney General's office would be a good solution for trying to ensure that this law actually is given the force and effect that it could be given. I would definitely state that this extensive stakeholder process, the passage of that bill is a statement of legislative intent, that in Minnesota, the desire on the part of the legislature is for this law to be used. And I would have to say that it is underused. It is not being used as intended at the current time. A lot of that bill was kind of geared towards the idea that we want to encourage early intervention and we want to encourage continuous care. Generally speaking, I would say that there still is a great amount of potential with that bill. And I think the proposal here is geared towards the idea that we want to do whatever we can to try to ensure that that bill and that law are given every opportunity to provide the excellent care that it can be able to do, but has not been able to do so far. I have reviewed carefully the opposition statements and just want to mention, from the perspective of my organization, having looked at very many civil commitment statutes and schemes throughout the entire country and how this compares, that among the reasons why you might want to consider having the Attorney General's office involved in this process, which I realize is not something that traditionally has been the case, is that the Attorney General's office is, generally the role that they play can include being the attorney of the people. There are definitely perspectives and constituents who maybe are not having their interests as represented by the current process and the way that the law is being implemented as could be the case. Generally speaking, there are a number of opportunities to really research what is currently happening and to identify where there are weak points and where things could be bolstered with additional support. If there are needs for any kind of changes, the Attorney General's office is a good place to do investigations. So thank you very much for listening to my testimony, and I'm happy to take any questions.
Our next testifier, thank you very much. Our next testifier, I believe, is online, Rebecca Walksmouth from Northern Tranquility Mental Health Services.
Okay.
Could you please unmute your microphone, identify yourself, and begin your testimony?
Good morning to the committee. My name is Rebecca Walksmouth. I am a psychiatric nurse practitioner who works in Minnesota, mostly in the Duluth area. And I'm here testifying to support this bill just because my practice is pretty much 100% people with severe persistent mental illness and developmental disability, and so I deal with civil commitments on a daily basis. And right now, the process of initiating a civil commitment, continuing a civil commitment, supporting the person while they're on it is very inconsistent. There's a lot of times when the patient, the family, myself have questions, and nobody really knows the answer to these questions about the civil commitment, so having someone who is coordinating the entire civil commitment process would be super helpful in terms of that and with consistency across the state. In addition, I work with a lot of counties, but I mostly work in St. Louis County, and it's extremely difficult to get someone onto a civil commitment, which is what other people had kind of mentioned with people falling through the cracks and not getting the mental health care that they need. We're often told that a county won't approve a civil commitment unless the person is hospitalized, which is something that we are trying to avoid, hospitalization with having a civil commitment, and the person getting that support so that they don't end up hospitalized or in jail. I've attempted to get outpatient commitments for people, and because I can't, they do end up hospitalized, they end up in jail, they end up homeless. And if someone is already on a commitment, it's difficult sometimes to get that commitment extended or re-upped, and so then the person decompensates mentally and again ends up hospitalized in jail or homeless on the streets. And this bill would also give, the individual counties funding to support these people before they end up, in the criminal justice system. It also makes more sense financially when a person decompensates mentally or their developmental disability interferes with their daily life. They end up in jail or the hospital. That's thousands and thousands of dollars per day for that person to be sitting in the hospital. And this would provide a support network. A civil commitment provides them with a safe place to live, person-centered care planning, helps the person have their best quality of life. Severe persistent mental illness, developmental disability, those are lifelong issues. They're never cured, they never go away. But civil commitments help the person get the support that they need. And I have seen my patients personally who go on civil commitment, I've seen them improve in terms of functioning, their mental health, their happiness. They're able to get jobs and keep jobs, engage in hobbies, integrate into the community, learn independent skills, and manage their mental illness symptoms when they are on civil commitments. So thank you for listening to my testimony, and I am also happy to answer any questions anyone has.
Thank you very much. Our next testifier is Mary Ann Jones. Ms. Jones, please introduce yourself for the record and begin your testimony.
Ms. Chair and members of the committee, my name is Mary Ann Jones, and I would like to share the reality of my experiences in dealing with the seriously mentally ill. I am in support of Senate File 1492. The county should be held to a higher standard of accountability when services are needed instead of just shooting from the hip and hoping that the minimum services will suffice. I am the mother, legal guardian of my adult son David, but also I am a retired deputy sheriff from San Diego, where I worked in both male and female correctional facilities, worked in patrol. I was also on the psychiatric emergency response team, having been in the trenches both on the personal and professional level. Families would tell me, "You just don't understand, deputy. They will not admit that they are ill or they refuse to take the medications." I know this all too well. At the end of my shift, I would go home to my son, David, who is schizophrenic, developmentally delayed, and addicted. David would also refuse to take his medications and did not believe he was ill. Schizophrenia is considered a serious mental illness. Individuals are unable to recognize their illness, and this is an organic brain disorder. It is called askinesia. It is impossible to talk to a person out of this madness. I've tried for over 20 years, and I have been very unsuccessful. It is a very unforgiving and misunderstood symptom. Fast forward 20 years later, I find myself still in the same predicament of the families I tried to help. Those that are seriously mentally ill are unable to consent to care. The system is set up only on a voluntary basis. A mandatory civil commitment must happen for medication purposes at the very minimum. This will provide a platform for stabilization and allowing the individual to arrest their symptoms and manage their everyday activities. There is a small population of seriously mentally ill or that are not receiving any care. My son David is one of them. He has been a resident for 11 years in Minnesota. Over the years, I have written to every conceivable person in local, state, federal levels. It was either no response or I don't handle that issue. Since 2015, David has been hospitalized 13 times, 2 civil commitments, 1 Welsh's order, 1 provisional discharge only to be removed prematurely by St. Louis County. He's been homeless twice, once for 10 months and once for 6 months. David's care requires a civil commitment to establish stabilization and long-term behavioral health hospitalization. On October 14th, David was removed from a civil commitment against medical advice. I was told he was on the civil commitment too long. Since then, David has spiraled out of control. David lives day to day tormented by his own mind. He hears voices and is paranoid. He will not let anyone prepare his food. He believes he is being poisoned. He allows himself to eat once a day. David believes he is the heir to the Walmart fortune and is an operative for the KGB to bankrupt this country. Personal hygiene is non-existent. He places himself in unsafe situations by sitting on a busy railroad tracks, leaving the group home in sub-zero weather, not wearing a jacket, gloves, or hat. This has happened twice this winter. Law enforcement responds to both incidences and refused to take David in for a psychiatric evaluation or, at the bare minimum, a medical evaluation for hypothermia. It has been a hands-off approach. They are torn between policy of the department, laws they are supposed to be upholding, and being told there are no beds at the local hospitals. This leaves families with no options. Law enforcement is the only lifeline we have. David presently is roaming the streets of downtown Duluth. He left on March 12th after midnight dressed in black and walked 17 miles to downtown. Absent of care has left David on the threshold of death twice in 2015 and 2017. Because David suffers from schizophrenia and he thought he was being poisoned, he drank copious amounts of water and coffee to flush poison from his body, resulting in sodium depletion of his system and causing his brain to swell, compromising his respiratory system, resulting in grand mal seizures. He was hospitalized in an intensive care unit. While on a ventilator, a social worker tried to talk me out of a civil commitment and go against doctors' recommendations. They wanted me to consent to community resources. Here's a picture of David. I don't know if you can see it or not. David's psychiatric nurse practitioner has filed 2 petitions for a civil commitment in August and October 2024, denied. David was hospitalized in November 2024 for severe symptoms of schizophrenia, denied. David's delusions have caused him to act erratic and become dangerous. There are times when he doesn't even recognize his own mother and has attempted to throw me out a window and trying to kill me. When stable with medications, he does not entertain these thoughts. It may be well-meaning the county attorney believes that they are protecting the civil rights of the mentally ill, but they are withholding the care that my son and others so desperately need. The pre-petition screening team receives the paperwork, including physicians' statements. It is maybe forwarded to the county attorney, or maybe not. It stops there. No petition is placed on the docket. The judges have no idea how many civil commitments are being discarded. I have spoken to many physicians and social workers. They are baffled and do not understand why civil commitments are not being utilized. I have witnessed this firsthand as St. Louis County is not petitioning the court for civil commitments. It has been 11 years and St. Louis County has been unable to secure a bed and refused to provide a higher level of care for long-term in a behavioral hospital for psychiatric stabilization and therapy for my son David. I applaud the Republican and Democrat legislators that are addressing this. Establishing accountability at the state and county levels is paramount with the issue and must be on the same page. The civil commitment coordinator appointed by the Attorney General's office will be able to collect data and determine why our most vulnerable adults are being denied care at the county level. Minnesota's civil commitment statutes are considered by most the nation's best, yet they are only written in formal format and hollow in action. Much is needed in engagement services, outpatient civil commitments, and provisional discharges. May I suggest comprehensive training on recognizing the symptoms of asphynosia, lack of insight, for all agencies that deal with the mentally ill, including civil commitment county attorneys, prescreeners, social workers, and law enforcement. Thank you for your time and hearing my testimony, and here's my son, he's doing well.
Thank you, Ms. Jones. Thank you for sharing your story, and thank you for all that you've done to support your boy.
Thank you.
Our next testifier is Sue Aberholden. Please introduce yourself for the record and begin your testimony.
Thank you, Madam Chair, members. Sue Abderholden, Executive Director of NAMI Minnesota, National Alliance on Mental Illness. We are a statewide grassroots organization dedicated to improving the lives of children and adults with mental illnesses and their families. And I will note that nearly 100% of our board staff and volunteers either live with a mental illness or have family members. I have family members. NAMI Minnesota is not supporting Senate File 1492 today, along with many other mental health organizations. When the major changes to the Commitment Act were adopted in 2020, it reflected the consensus of a committee of over 20 people representing every point of contact with the commitment process. And this was actually led by NAMI. We identified problems with the Commitment Act and its implementation and worked hard to find solutions. And I will say that process took us 3 years. The end result is a Commitment Act that is recognized by the Treatment Advocacy Center as an excellent law. This bill didn't have some of that input engagement from all of those particular stakeholders, and so some of these components are frankly confusing and are duplicative of what already exists with other state agencies. The Engagement Services Grant is something that was actually an idea of NAMI and that we tried for several years to get funding for, and we did finally get funding for it last year. And that funding is actually through the Department of Human Services. DHS will be issuing the RFP either today or early next week, and then the grantees will actually be required to evaluate the project and promote it in their community. It's duplicative to have the AG office also involved in this program and giving out those grants. The advisory committee doesn't really reflect the broad group of people that have traditionally been involved in commitment and community health issues, and we're not sure why the AG would be appointing so many of the members. There are existing committees that are looking at these issues, including the Priority Admissions Panel, the MIND Task Force, and the State Advisory Committee on Mental Illness. The sequential intercept model is kind of the gold standard that we use to identify how to divert people from mental illnesses out of the criminal justice system. And I had provided a copy, but it really, you really go through each stage, you know, before the police intervention, when the police arrive, the whole thing, to really figure out, so how do we divert people out of the criminal justice system? 21 counties have been involved in what's called the Stepping Up Initiative that use the sequential intercept model to, again, try to work on that. We're just wondering why we would start a different data project within the AG office. One of the most successful ways to divert people from the criminal justice system are our county mobile crisis teams. We want a mental health response to a mental health crisis. They were given one-time money last session of $8 million, and that money doesn't continue into the next biennium. We actually do know what works, and we should fund it. There are 19 adult mental health initiatives covering all counties in the state. The AMHIs use state grant funds to fill in gaps in coverage, including services and supports that are not covered by insurance. Their goal is to provide consistent and effective care to people with serious mental illnesses. In 2024, a study was done to catalog the evidence-based practices that are used across the state of Minnesota. They also have to report to DHS on the services that they provide and who they serve, and so to have them now report new data to the AG's office, we think is duplicative. The Ombudsman for Mental Health and Developmental Disabilities actually has a civil commitment training and resource center, and they're tasked with providing technical assistance on the Commitment Act. The Attorney General's office, has been said before, has not been involved in commitment or enforcing commitment or studying commitment in the past, and I don't actually know how much authority they have over county attorneys on the Commitment Act. I will say that there are real issues with implementation of the Commitment Act, and we see that through the calls to our office, nearly 4,000 a year, and talking with other mental health organizations. But I don't think the bill actually addresses them. The biggest issue we see, frankly, right now, in the last 3 years, is police not willing to do transport holds due to change in the use of force law. We also see people being discharged while committed to shelters because housing isn't available, and because if they have a bed in the hospital, they don't rise to the top of the priority list in housing programs. If people do not follow their treatment plan, hospitals won't take them unless they meet medical criteria, and there's nowhere else to take them. Now, I will say that implementation of the Commitment Act really depends on a robust mental health system. And as I have said before, we have not finished building the mental health system. This session, the Mental Health Legislative Network, which is a coalition of over 40 mental health organizations, have numerous bills to try to address these gaps in our system, including increasing rates so that we don't have a great workforce shortage and that we can really expand and be able to allow people to access those services. There's bills on housing, because we know housing is critical to recovery. Funding for the first episode of psychosis program and bipolar program, because we know, again, if we intervene early, that really does help. And actually creating a task force to look at this whole issue of transport holds. I mean, I'll be honest, we really felt that this would benefit people and move it in the right way. We would support it. But we actually see that it is kind of duplicative of the work of the state's mental health authority, which is the Department of Human Services. Thank you for the opportunity to testify.
All right, any questions or comments from members of the committee? Senator Limmer.
Madam Chair, thank you. Senator Latz, after hearing testimony, it seems like this bill may be duplicative in a few areas. Is that intentional, or is that just unknowing? Ms. Abder-Holden's comments reflected that. Do you have anything in response to that?
Senator Latz.
Madam Chair, Senator Limmer, first of all, let me say I appreciate Ms. Abder-Holden's input and all of her work over the years in this space. I know her work is motivated by passion and compassion for people suffering through experiencing mental illness. There is some duplication in this bill. Part of that is so that we can be in a position to provide some additional funding in the spaces where that's recommended here through the 2 grant programs that are included here. And I'm certainly willing to take a look at whether or not the timing of any appropriations, if we have funds available to do it, would dovetail with the existing grant programs that are there as well. So I'd love the opportunity to sit down with Ms. Abder-Holden and with our staff to take a look at those questions. I do think that we need, as we heard from Ms. Abder-Holden, there are different levels of implementation and effectiveness throughout the state in different counties. And thus far, it seems that, well, DHS plays a significant role here. They have not been able to make sure that all of the counties have all the information or all the capacity to do the best that they can do for individuals that have mental illness and need their help. And I think it'd be important to have this coordinating position to gather that information and to provide that view and that incentive, and to establish and promulgate best practices, and then provide support to the counties for implementation as well.
Madam Chair?
Senator Limmer.
Thank you. Senator Latz, I'm not sure if if it's the right time to point blame on a department, there may be data subsets that might point us in that direction. But I think if there's any blame to be pointed anywhere, it's at us, the legislature. And the reason I say that is I remember early when Representative Siegel, and you may remember Representative Siegel, she promoted the repeal of putting people in large institutions if they had a mental disability. And this is about 40 years ago. And she was successful at that. But shortly after she did that, within a year or 2 years, she passed. And the legislature has not recognized her direction of replacing those large institutions with facilities and the focus that really we should have done. So for the past 40-some years, we've been a little inadequate in trying to catch up to what Gloria Siegel pointed us in the right direction on. I'm a little concerned that we're asking the Attorney General at this time to get involved in this, which is really the Department of Human Services. And so I don't remember the Attorney General having this capacity or this oversight before. And so I'm concerned that are we maybe going in a direction where we're relying on the Attorney General's office to do things that really is the responsibility of the Department of Human Services. I haven't found the kernel yet that says this is the appropriate path we should go at this time. I think it really rests with us in creating adequate resources, and that's a big lift. I'll admit that. It's very, very expensive, but somehow we've just kind of, as a legislative body, kind of shirked that direction. So my question, if I can sum it up, is why do we think the Attorney General's office is going to do any better than the Department of Human Services is kind of a mystery to me. And maybe you could shed some light on that.
Senator Latz.
So, Madam Chair, Senator Limmer, let me start by saying I'm not interested in casting blame, but in solving problems. And that's what this bill is intended to try to accomplish here. I knew Representative Gloria Siegel. She represented St. Louis Park, which is my community. And I have a great deal of respect for her and the work that she did. And she still has many family members around, been involved in public service in one way or another as well. And you're quite right, Senator Limmer, that deinstitutionalization was great as far as it went, but our community failed, our state failed to provide adequate resources for alternate supportive places for people who needed the care to get the care. There are plenty out there, but not enough to meet the need. And that's been ongoing for 20 or 30 years. When I was at the Attorney General's office, my first position was as an Special Assistant Attorney General in the Human Services Division, where one of my tasks was to get Jarvis orders, which are court orders to impose neuroleptic medications on the state hospital patients when they did not recognize that they had a need for medication. That was always the first threshold thing we had to point out, was that they didn't understand that they had a mental illness, so they weren't capable of making those kind of decisions on their own. So the Attorney General's office does have a long history of involvement, certainly through the Human Services Division, in mental health issues. It is apparent that not only the legislature has not provided adequate resources, but that the system hasn't been built out. Now, where ultimately we're going to place responsibility for giving more information to the legislature so we can make important decisions about funding and so on. What I'm proposing here, with those of us who are supporting this bill, which, by the way, includes Senators Draheim, Abler, and Utke, who are my co-authors on it, and Senator Hoffman, who agreed yesterday also to be the fifth co-author on the bill, is that the Attorney General's office can bring an additional and I think fresh voice to the table here. They have these ongoing interactions not only with the human services people that DHS brings, but also with law enforcement, with the criminal justice system, with the civil system, more directly through all sorts of elements of the Attorney General's office work. So they have that capacity in those relationships. And I think it's important at this point we bring in a set of fresh eyes to look at this system, and not only to identify where these gaps are occurring, make sure the data is gathered and disseminated appropriately and comes to our attention, but also to provide incentives and some oversight, some accountability to local counties, local law enforcement agencies, so that we make progress in addressing these issues.
Senator Limmer? Senator Kroon.
Thank you, Madam Chair. Not my area of expertise at all, so I'm just kind of struggling to put this together, what it means. But on page 5 of the bill, 5.1, where it's talking about all grantees, can you educate me? Who are the grantees in that subdivision? Like, how do you envision that working?
Senator Latz.
Madam Chair, Senator Kroon, they're referring to grantees that are identified in subdivision 1 of that, those recipients that provide engagement services, outpatient civil commitment services, and provisional discharge services. Specifically, the funding would be supplemental to the funding to the counties to expand the county's capacities. So I think ultimately the grantees there would be counties as I read this.
Senator Kroon.
Thank you, Madam Chair. And then going down just a little bit, and thanks for that answer. I was kind of confused by that, but going down just a little bit into 5.6 to 5.10, again, that's relating back to the grantees, but it seems like there's some confusion over who would be hiring the staff that's set forth in 5.6 to 5.10. That wouldn't be staff the Attorney General's office is hiring, is it? I mean, it would be the grantees that you previously identified. Am I reading that correct?
Senator Latz.
Madam Chair, Senator Kroon, that's correct.
Any other questions or Senator Howe?
Thank you, Madam Chair. And Senator Latz, I appreciate that we're finally trying to do something because you are absolutely correct. We failed to build out the system. I mean, we got rid of the state hospitals and failed to figure out how to treat them, how to put them. We started the system and we didn't build out the system. My concern is I agree. I don't know if putting this in the AG's office is the right place. I would like to see that type of a system put in with HHS because I think that's who has the expertise. You're right, putting a fresh set of eyes, but the way this looks is you got a coordinator, you're going to put the grants down to the counties are going to be hiring the people. Why couldn't we run that, and why shouldn't it go through HHS, who, in my opinion, has a much better expertise on that than what we were going to find in the AG's office? And we're going to have I think we're going to have that huge learning curve to get our heads wrapped around that to actually establish and do something good. And that's my concern. I applaud the efforts, but I think we're just putting our efforts in a different place rather than where I think the efforts should be continued. Thank you.
So, Madam Chair.
Senator Latz.
Senator Howe, I appreciate your comment, and first I'll note that the grant programs are only a portion of what would be administered or done by the civil commitment coordinating position in the Attorney General's office. So it's not only a grant making position. And I certainly would want to take a look at that very question, whether or not that portion of it ought to be sent back to DHS or whether it ought to be a part of the Attorney General's responsibility. But aside from that, I think it's still pretty important to have an agency outside of DHS working on this now. You know, again, I don't want to get into a blame situation here at all, but we've had decades now where we've got people who are entering the system and there's no place to put them. Our jails are the largest single institution now that houses people with mental illness. That's unconscionable. To try to remedy that, we passed a 48-hour law in the last several years that requires that the jailers move people with mental illness out of their facilities within 48 hours of them coming in. And they can't comply with that because they've got no place to move them to. We've got people who are subject to civil commitment that should be put in facilities that are instead committed to the community, just generally. So there's oversight by the courts, but there is nothing more really provided. I've got a client in exactly that situation right now, actually, who interacted with the criminal justice system. And we've had Rule 2001s, we've had Rule 2002s. His family has been desperate to get him help. And the criminal justice system can't provide him with the help. He had to wait many weeks before we could even get forensic psychiatrists in to interview him, and then he wouldn't show up because he's out on the street. So our emergency rooms are filled to capacity, and there's no place for them to go. So the fact is, the system isn't working the way it was intended right now. I think it's important to get outside of DHS now, have another place to look at it. And we consider whether perhaps that ought to be the courts instead of the Attorney General's office, because so much of the individuals affected here are run through the court system. And we concluded basically that the courts are, they've already got plenty of things to do from that standpoint. And this would be, frankly, we would lose a certain element of oversight. Something ends up in the judicial branch. And I think the Attorney General's office is a better place to put it.
Madam Chair.
Senator Howe.
Thank you. Thanks for those comments, Senator Latz. And I think where we agree most wholeheartedly is there's no place to put these folks. And I don't know if this is going to fix that problem. I think that's where we should have probably in recent years put our funding, is to actually put those, build those locations where we got places to put them, because there are no beds anywhere. And that's our real problem, and that's why they end up in correctional facilities. We got no place else to house these folks. That if we actually put forth the effort to build out the system and actually have a place for these people to get the treatment they need so they can function in society, and some of these folks are just not going to function in society, but we need those facilities that we currently don't have. And whether we have somebody looking, we just don't have the bed space because we didn't build out the system. And I think that's our biggest problem. And I think that's where our efforts really need to go, because everybody knows that we got folks that need to be committed. We got no beds. And if this does have that in there, I just guess maybe I missed it, but I think that's our big problem that our state currently faces. We just don't have the bed space.
So, Madam Chair.
Senator Latz.
And Senator Howe, you're right, but that's not the only role that is provided for in this bill. If I can draw your attention to page 1, line 20, subdivision 3, identified as duties of civil commitment coordinator. The next, that whole subdivision there has 10 separate points of responsibility that would be assigned to that coordinator, one of which, or two of which are grant administration provisions, but the remaining 8 are separate from that. And they include not only maintaining the advisory committee, but it's also developing and providing best practices and guidance to all of those involved, to committing courts, counties, designated agencies, treatment facilities, and community-based treatment programs, advocating for statewide capacity for all of these needs, engagement services, outpatient civil commitment, and provisional discharge, providing technical assistance to local and regional level organizations that are tasked with monitoring participants civilly committed, providing guidance on data collection of the outcomes for those categories, aggregating and analyzing that data, making sure that data is properly handled under Chapter 13, working on a public awareness campaign to educate the public about the availability and effectiveness of engagement services. So it's pretty broad-based in this space as well, and that would help lay the foundation also for this legislature to take a look at what more can be done and needs to be done in this space to help our mentally ill residents in Minnesota.
Any other questions or comments from members of the committee? All right. Seeing none, I will move that Senate File 1492 as amended be recommended to pass and be referred to the Committee on State and Local Government. On that motion,
Madam
all
Chair.
those, I'm sorry, Senator Latz?
I think just as the chair, I'm not sure you can make the motion, so I'd like to make the motion.
Be my guest, Senator Latz.
Madam Chair, I move that Senate File 1492 as amended be recommended to pass and be re-referred to the Committee on State and Local Government.
On Senator Latz's motion, all those in favor say aye. Aye. Any opposed say no. The motion passes and the bill is on its way to Committee of State and Local Gov.
Thank you, Madam Chair. Senator Limmer, you're well protected by my sheriff.
I was getting nervous, Mr. Chair.
And your sheriff, I might add, yes. Senate File 2453, Senator Limmer, go ahead and...
Mr. Chair, I'd like to start with Senate File 2228.
I'm sorry, let's back up. Senate File 2228, Violent Crime Enforcement Team's appropriation. The intent, members, is to lay this over for possible inclusion. Senator Limmer, please describe your bill.
Yeah, thank you, Mr. Chair. Senate File 2228 is a bill to add funding for the VSETs, or the Violent Crime Coordinating Council. As a little backdrop, in 2010, the legislature established the Violent Crime Coordinating Council to provide guidance related to the investigation and prosecution of gang and drug crime. Minnesota VSETs are specialized law enforcement units. They're composed of officers from various local, state, and federal law enforcement agencies and are focused on investigating and combating violent crime, particularly in the relationship to gang activity, firearm offenses, drug trafficking, and other criminal activities. As we all know, violence in our cities has surged since 2018, and that increase has not fully receded. We also have opioids and other illegal drugs pouring into our state, as well as other elements that may come along with other activities involving human trafficking and other concerns, all of which raises concerns for Minnesota's health and safety. Senate File 2228 allocates a one-time increase in VSET funding of $3.5 million in fiscal year 26. Minnesotans are concerned about their safety. This additional funding will assist law enforcement in keeping up with rising costs, allowing agents to dedicate more time to addressing violent crime and overdose cases, while also enabling a more effective response to challenges posed by criminal activity. With me today is Sheriff Dewana Witt from Hennepin County Sheriff's Office to give testimony. I also have Major Rick Pelayo, and he's on hand for other questions.
Which sheriff wants to go first? I'll let you two fight that out.
Good afternoon. Thank you, Chair Latz, Senator Limmer, and committee members. I'm Dewana Witt, Sheriff of Hennepin County. I'm here today with Major Rick Pelayo to speak to you about the importance of the Violent Crime Enforcement Teams, otherwise known as VSETs, and the critical need for additional funding to support their continued effectiveness. VSET funding is critical to support 21 Minnesota task forces' ongoing efforts to combat violent crime and address the fentanyl crisis that is devastating our communities. Starting in 2022, approximately one person has died every single day from a fentanyl overdose in Hennepin County alone. And this crisis affects every county in Minnesota. As a result, our task forces turned their attention to fentanyl. In addition, we focus on seizing volumes of drugs that affect the drug supply in our area. Rather than focusing on making many arrests for smaller cases, albeit both are important, is why we began tying those smaller cases together into bigger ones, reaching the top tiers of criminal enterprises. The results speak for themselves. While drug arrests have decreased, we have made significant increases in seizures of drugs, weapons, and other illegal goods. Since 2022, statewide VSET pill seizures have tripled, and powder fentanyl seizures have doubled. In 2024, our Hennepin County Task Forces alone seized 307 illegally possessed firearms, some of which were ghost guns or had switches. Nearly 70,000 fentanyl pills, over 17 pounds of fentanyl powder, 260 pounds of methamphetamine, and nearly 65 pounds of cocaine. Again, that's in Hennepin County alone. In terms of the values of seized goods, VSET teams provide an estimated 600% return on investment through the seizure of illegal goods. Every dollar invested in VSET teams takes away from human trafficking, gun trafficking, deadly drug smuggling, to ultimately save lives. Despite these successes, we are facing a critical challenge. Technology costs have increased dramatically, while VSET funding has remained stagnant for quite some time. Without adequate funding to keep up with the rising cost of technology and other essential resources such as insurance, office space, evidence space, technology, just to name a few, our ability to continue making these gains will be severely compromised, ultimately giving drug dealers an even greater advantage over law enforcement. For these reasons, we have made partnerships with the state task forces. We talk with the Department of Public Safety and specifically advanced legislation to address this important need. In addition, I currently sit as the vice chair of the North Central HIDA. HIDA is the acronym for a high-intensity drug trafficking area. North Central HIDA covers Minnesota, the state of Minnesota, and Wisconsin. Minnesota has become a distribution hub in the upper Midwest for drug cartels. This past week, myself and others from North Central HIDA executive team traveled to San Diego to meet with the executive team from the San Diego Imperial HIDA team. This meeting was quite crucial as important information was shared. As we know, the state of California deals with a significant amount of drug trafficking. We also know that what they see there, we will not, if not already, see the same things in the upper Midwest, specifically here in Minnesota. Some of the most important takeaways for me at that meeting: individuals and cartels are always proactive. Every time one of their smuggling or trafficking rings are busted, they already have a plan B, C, and D in place. Their intelligence is advanced. Their ability to recruit people to smuggle their drugs into our communities is nonstop. The use of their technology continues to grow. Meth seizures have been increasing, and as a result, smugglers have been resulting in using or smuggling liquid meth. Again, they are being ferocious in getting these poisons into our communities. Xylazine, which is a non-opiate sedative, and a muscle relaxant, which is only authorized in the U.S. to be used by veterinarians, is increasing in the state of California, and we also know it's in our communities here in Minnesota. Chair Latz, Senator Limmer, and committee members, we have incredibly brave men and women that spend countless of hours doing a very dangerous job of keeping these deadly drugs out of our communities. And we need your help to continue to do our best to stay ahead of the vicious people that are literally killing our children, our family, and our communities. Senator Limmer, I want to thank you on behalf of our office and all the task forces across the state for leading on this request. I hope this committee can find the necessary funds to make this happen this year. Unfortunately, the people who are preying on our communities aren't stopping. So give the men and women that are doing this work, I'm asking you, an edge over them. Thank you for your time, and Major Pelayo and I will stick around if there are any questions.
Thank you, Sheriff Witt, and I welcome the committee, Major Pelayo. I know you're available to answer questions. Is there anyone else in the room that wants to testify in connection with this bill? Any questions or comments or discussion from members of the committee? Senator Cruin.
Thank you, Mr. Chair. And I know that the primary purpose of VSET is public safety, but I'm looking at your letter and it says that that VSET has provided an estimated 600% return on investment through the seizure of illegal goods. Where do those funds end up?
Major Pelayo.
Thank you, Chair Latz and committee members. The return on investment, the way that's calculated is for every dollar worth of drugs seized, the street value, how much does that compare to how much VSET funding we get? So it's not like an income, it's a way for us to calculate what's our return on investment. If you're giving us, say, $10, but we seize $60 worth of drugs, then we're looking at that as a victory, really.
Mr. Chair.
Senator Cruin.
Thank you, Mr. Chair. So the 600%, it's not like you can convert those into money that would go back into the fund or something like that. This is just the value of the goods that you confiscate through the program as just kind of a marker compared to the funding that you receive for the program. Is that right?
Correct.
Any other questions or discussion from members of the committee? Not seeing any. Senate File 2228 is laid over for possible inclusion. Thank you.
Thank you. Have a good afternoon, everyone.
Senator Limmer, which bill would you like to take up at this time? You got 4 of yours in a row here, so.
Mr. Chair, Senate File 2453.
Senate File 2453 is before the committee. Sheriff Larson, if you're in the room, come on forward for your testimony. There is an A1 amendment which is here being distributed to members at
Mr.
this
Chair, I'll
time.
move the A1 amendment, delete everything.
Senator Member Limmer moves adoption of the A1 delete everything amendment. This is an author's amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment's adopted. Senator Limmer, tell us about this bill.
Thank you, Mr. Chair. 2453 is an underlying law which was established, or to the bill, the underlying law was established a few years ago. This legislation seeks to expand on its success by ensuring greater consistency in investigations of criminal sexual conduct cases involving military personnel on state-owned military facilities. The additions to existing law will provide uniformity and clarity in handling allegations of criminal sexual conduct involving all branches of the military, ensuring thorough and consistent trauma-informed, victim-centered investigations regardless of the jurisdiction. In preparation for this legislation, the Minnesota Sheriff's Association engaged with key stakeholders, including representatives from the BCA, the Bureau of Criminal Apprehension, and the Minnesota Department of Military Affairs and the Minnesota National Guard to ensure the bill effectively addresses the needs of both military personnel and law enforcement. Located in Morrison County, Camp Ripley is a 53,000-acre regional training facility. It supports both civilian and military training requirements, making it an essential resource for public safety and national defense. Most activities of military in Minnesota focus on Camp Ripley. It serves not only the National Guard, but also armed forces across the country, including all branches of the military, reinforcing its role as a premier military training site. Between March and September, Camp Ripley housed more than 65,000 military personnel, nearly doubling the population of Morrison County. To say the least, it's used quite a bit, and a great number of personnel go through there. However, there are challenges when it comes times of law enforcement issues that arise there. As a result, I'd like to introduce Sheriff Sean Larson from Morrison County.
Sheriff Larson, welcome to the committee.
Thank you, Mr. Chair, members of the committee. I just appreciate the opportunity to speak. Pretty much everything said is right on par. I just want to add a few things that the way the intent is for the language in the bill, it didn't line up. And we had a call from the BCA back in July of 2024, and they said they received information there was a sexual assault on Camp Ripley. They said the issue is it doesn't meet our criteria. It doesn't meet the language in the law because the language as it stands is it has to be the accuser and the victim have to be part of the Minnesota National Guard. In this case, it was two Iowa Guard members. So in light of that, that's why we're back in front of you today to change the language to all U.S. forces and all branches of the military.
Anyone else in the room want to testify on this bill? Not see, Senator Limmer.
Mr. Chair, just to supplement the testimony, I have an email from the Minnesota Department of Military Affairs, National Guard. They are stating that they're supportive of the bill as proposed in the A1 amendment from Colonel Eric Athman, Director of Operations.
Any committee discussion? Members, the intent here is to move this bill to the Agriculture Veterans Committee. Senator Limmer.
I have nothing more to say. I think it's fairly straightforward, Mr. Chair.
Senator Limmer moves that Senate File 2453 as amended be recommended to pass and be re-referred to the Committee on Agriculture, Veterans, Broadband, and Rural Development. All those in favor say aye.
Aye.
Aye. Opposed? Motion prevails.
Have a great day.
Thank you, Sheriff. Safe drive back. Senator Limmer, which bill is next?
Senate File 794.
All right, Senate File 794 is before the committee involving the Government Data Practices Act. You have an amendment to this as well, I understand. Is that correct?
That's correct. The author's amendment A1.
It is being distributed to committee members as soon as that's out. We'll do that. While that's happening, Senator, why don't you give us a description of the bill? Then we'll have the amendment.
Mr. Chair, as the amendment is being passed out, it's a technical amendment changing some references in Chapter 13. As I begin Senate File 794 presentation, this provides, or Senate File 794 provides that a violation of the Official Records Act is subject to the same remedies and penalties as those under the Minnesota Government Data Practices Act. A little bit of history to frame it. A data requester named Tyler Howe sued Minsky a few years ago under the Data Practice Act for access to data about a contract he bid on. And then he also sued under the Official Records Act due to the fact that Minsky had destroyed some of the data. There is a private right of action in the Data Practice Act, but there's no explicit private right of action in the Official Records Act. Halva's argument was that the Official Records Act must have an implied right of action in order to make it enforceable. The Supreme Court in Minnesota ruled in 21 that the Official Records Act did not have a private action itself, but held that it could be enforced through a lawsuit brought via the Data Practice Act. Prior to Halva, the Data Practice Act remedies in 13.08 just pertained to violations of the Data Practice Act. And the 13.085 remedies just pertain to data access violations of the Data Practices Act. Hope you can all follow this. After Halva, 13.08 and 13.085 can be used to sue for failure to preserve official records. Elsewhere in state statutes 1517 says that 1, the government entities must create and preserve official records so that the public knows that what the government is doing. 2, statutes 138.17 sets out a process for determining how long those records must be preserved. That's a retention. And 3 requires that the government entities only destroy records according to an approved record retention schedule. Well, now, if a government entity destroys records improperly, a private citizen has a private right of action to sue under Data Practice Act to enforce the Official Record Act. In order to make this more simple, I'm going to pass it over to Mr. Ealing from, what's the new group now?
Minnesotans for Open Government.
There we go.
Mr. Ealing.
Mr. Chairman, members, Senator Limmer, thank you for the time. Senator Limmer is absolutely correct about the procedural history of this case that has led to the bill that's before you today. I just want to talk at a high level about how the different pieces of our open records framework interact so the committee has an understanding of how these things work together. You have the Official Records Act passed in 1941, which basically tells the government that they have to make and preserve records that are necessary to understand what the government is up to. Then you have 138.17, which is the records management statute that says you have to put these records on a schedule that says how long you need to preserve them for, and you can only destroy them according to that schedule. Then you have the Data Practices Act, which allows access to those records or the data within those records and provides the private right of action that Senator Limmer has mentioned. So now that after the Halva cases have been decided, we just felt that having this bill come forward to provide a clear cross-reference in the Official Records Act, recognizing the outcome of the Halva case was useful. So we support the bill.
Thank you. Any questions for Mr. Ealing? Anyone else in the room want to testify on this bill? Wouldn't be the first bill that's come here following a court decision just to have us codify the results, or sometimes fix the results. All right, members, the intent here then is to move this on to state and local government. We do need to adopt the A1 technical amendment. Senator Limmer moves adoption of his author's amendment, the A1. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Senator Limmer moves that Senate File 794 as amended be recommended to pass and be re-referred to the Committee on State and Local Government. All those in favor say aye.
Aye.
Opposed? Motion prevails. All right, Senator Limmer, I'm going to choose your last bill for you. The only one we have here. Senate File 1987. Members, you're receiving a copy of it in your packet. The intention here is to lay this over for possible inclusion in the omnibus bill. Senator Limmer, tell us about your bill, please.
Thank you, Mr. Chair. Continuing on a transparency theme, I'd like to give a little background to this particular bill. Back in 2012, the Legal Services Advisory Committee was created. The court has required a written annual report on the work of this committee, including revenue received and grants made to civil legal service programs. Effective in July of 2025, the grant making has been done through the Legal Service Advisory Committee. That will make a transition to the State Board of Civil Legal Aid. And that State Board of Civil Legal Aid will be a new judicial branch agency independent from the administrative control of the court system. This bill emphasizes the importance of a smooth transition to the new State Board of Civil Legal and promotes ongoing transparency, accountability, and effective resource allocation for Minnesota's civil legal aid programs. The simple message is this: they're already doing this in the Legal Service Advisory Committee, and we want them to continue to do that in the new organization of the State Board of Civil Legal Aid. I think that pretty much sums it up, Mr. Chair. I think it's important to have clear data-driven reports, and it helps lawmakers review them and make informed decisions in the future.
Members, there is a fiscal note on the bill. It comes up zeros, so that'll help the chances of this bill becoming law.
Mr. Chair,
Senator.
there may be a question of whether or not there's a fiscal impact at all, since the previous organization already does it, and we're just shifting to a new organization. So we'll let the bean counters figure that out.
Anyone else in the room want to testify on this bill? Come on forward, please. Yeah, my point, Senator Limmer, is that the fiscal note that we have in our packet shows no fiscal impact.
Oh, I spoke too soon.
You can have some if you want.
We have enough problems, Mr. Chair.
Go ahead, ma'am. Welcome to the committee. Please introduce yourself.
Thank you, Senator Latz and Senator Limmer and members of the committee. My name is Bridget Jernander. I am the current staff person for the Legal Services Advisory Committee and will be transitioning to the program administrator of the State Board of Civil Legal Aid. I just wanted to say quickly that this bill is appreciated as a way to provide the transparency that Senator Limmer said. My only point I wanted to make is on the timing of the data collection. The report is due in the bill on January of odd-numbered years. Our data collection practices are that we get information from civil legal aid on a calendar year basis. And so the data is normally collected in March. So if we provide it in January, it would be approximately 1-year-old data with a bit of a later timeline. It would be more current, but that would be the only note is the timing, and we would be happy to provide the data collected.
Ms. Jernander, do you have a recommendation?
April 1st would allow us for the most consistent and current data. We could turn that around very quickly and provide it at that time. Or again, January would be a fine timeline before the session if you would like it. It just would not be as current as it is in March.
Senator Limmer, what do you think?
Mr. Chair, I think timely reports are best used by the legislature. If I heard it right, April 1st in odd numbered years would be suggested as the most appropriate. I would suggest oral amendment to strike January 15th on line 1.15, replace it with April 1st.
Any discussion from members of the committee? Senator Limmer moves that line 1.15 be amended by striking the words January 15 and replacing it with the words April 1. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted.
Suggestion, thank you.
Anything further on this, Senator Limmer?
No, sir.
All right, members, Senate File 1987 is laid over for possible inclusion in the omnibus bill. Senator Howe. So, members, we're going to hear Senator Howe's two bills. We will take a lunch break, and then it's our hope to reconvene around 1 p.m. after that. My goal is to have us out of here no later than 5. So just so you can try to plan accordingly. Senator Howe, do you have a preference which bill you take up first?
Let's take them numerically. Let's take Senate File 1427, please.
All right. Senator Howe, we'll take up Senate File 1427, Hometown Heroes Assistance Program. Ms. Otto, if you want to come forward as a testifier here. The intent, members, is to lay this over for possible inclusion. Senator Howe, tell us about your bill, please.
Thank you, Mr. Chair. And if the committee remembers, a few years back, we did the Hometown Heroes program that's administered by the Menfire. And basically what this bill does is just clarifies the scope and actually makes it more applicable to what the Hometown Heroes Act actually does. And to clarify that, we have Ms. Otto here to testify.
Ms. Otto, welcome to the Senate Judiciary Committee. Good to have you here.
Thank you, Chairman. Mr. Chair and members of the committee, I'm Rebecca Otto, and I am the Executive Director of the Minnesota Firefighter Initiative, or MinFire for short. Due to the occupational health hazards of being a firefighter, they have higher rates of cancer, cardiovascular disease, and PTSI than the general population. And it's important to note that over 90% of our fire service is volunteer in Minnesota. And so when the HHAP was passed in 2021, it met a big need that existed, and we're thankful to Senator Howe for helping us with that. You should have a results sheet for calendar year 2024 in terms of the type of help we were able to provide to firefighters. To date, we've paid out over $4 million in critical illness claims. We have provided peer support. We've provided lots of proactive preventative trainings to help firefighters protect their health. So this language is technical language. It's cleanup. I've been with MinFire for almost a year, and we want to make sure the statute reflects exactly what's happening. So peer support is clearly called out, very important for our firefighters. And then we tweaked the training language. And that is because before it said all departments to be trained basically every year, and now we make it available to all departments. And all of these services we provide to the fire service are no cost. So we would love to get the language clean, and there is no new money being requested. And I'm happy to answer questions.
Are there any questions for Ms. Otto? I'm not seeing any. Anyone else in the room want to testify on this bill? I'm not seeing any there either. All right, we're going to lay over Senate File 1427.
Thank you, Mr. Chair.
Senate File 2062, Senator Howe.
Thank you, Mr. Chair, and Senate
Staff will
File
distribute the packet.
2062, basically what this does, and it stems from a case in my district that one of the public officials was terminated, but the community didn't know why. And because the current statute allows them, because it was a community of less than 7,500, just barely less, and it allows cities less than a population of 7,500 and a county less than a population of 5,000, they don't have to disclose it. And the only way the public actually found out what happened to that public official in that town was because the post board revoked his police license. And that's how it got disclosed. Now, members, I will tell you that as far as I'm concerned, if you're in a community, I don't care what size of community, you should be told what your public officials have done wrong or are accused of being done wrong. So this just eliminates that population limit so that people know, just like every other community above 7,500 knows. And I don't understand why we have that blanket of coverage and pull down the shades on people that live in small communities. And I do have Mr. Ailing from Minnesota for Open Government here, answer any questions or maybe testify.
Yes, members, just to note also, Rich Neumeister has submitted a letter that's in your packet. Mr. Ailing.
Thank you, Mr. Chairman, Senator Howe, members. I know we're right before lunch. I'm not going to belabor anything. There are comments from our organization in your packet. From a technical standpoint, let me just walk you through why this ended up the way it did, and it's one of the fixes we've been trying to get for a number of years, as I know Senator Howe has been trying to get this fixed also. This particular part of the statute, the definition of who a public official is for the purposes of 1343, which is the personnel data section of the Data Practices Act, started to be changed back in the 1990s by Senator Marty, when a state official, high-ranking official within a state agency, was accused of some improper conduct, resigned before the final disposition of disciplinary action, when the underlying data about what happened would have become public. And so nobody was able to find out in that instance what happened. So Senator Marty made a change at the state level. Come 2012, there were changes made at the local level, but the stakeholders that were meeting at that time put this population cap in that even back then we flagged it as an issue that was going to cause a problem for small cities and counties. So we would like certainly to see that population cap lifted, meaning then that there would be uniformity in the public official definition and what data would be available across all cities and counties of any size.
Thank you, Mr. Ailing. Any questions for Mr. Ailing? Not seeing any. Senator Howe moves that Senate File 2062 be recommended to pass and be re-referred to the Senate Committee on State and Local Government. All those in favor say aye.
Aye.
Opposed? Motion prevails.
Thank you.
Thank you, members. It's now 12:35. We're going to take a 25-minute break here for lunch, reconvene at 1 o'clock. Thank you, members. We are in recess.